all wanted to leave when I did.
This controls the slides.
Awesome.
Left and right.
Perfect.
Just
Awesome.
to the right.
Thank you.
side.
I very much appreciate it.
And laser if you need it.
Okay, perfect, thank you. Just so you guys know a little bit about me, my name is Lauren Goldberg, and you've been staring at that for quite a while, so you already know that. I am the managing attorney at KP Law, which represents about 1/3 of the cities and towns in Massachusetts. And before I came there in the year 2000, I worked in the Public Records Division at the Secretary of State's office, and also as legal counsel to the state's elections division. So I've been in the public sector law business my whole life, and my whole working life, and I deal with the craziest situations that you could imagine in the public records and open meeting law areas. I know it's a great sounding expertise. You can imagine I'm very popular at parties. I know a lot of really good stories. If you have something you want to talk about tonight, it's best to talk about hypotheticals rather than to talk about actual things. So don't, try not to tell actual stories about actual people doing things that could be problematic. It's better to just ask an open-ended question. Hi, Robin. So something like, what would the rules be relative to whatever? The other thing is that we're going to talk about best practices, which is...
The open meeting seminar is beginning now. Thank you.
We're going to talk about best practices, which is different than, is there a defense to the statement that we may have violated the law? There's the right way to do things, there's the way you do them, and then there's if you don't do it exactly correctly, is there a way to still address that? So we're going to try to talk about best practices, and maybe you'll have some hypotheticals that you want to discuss, but there's not just one answer here. This is the answer I would give if you say, what's the best way for me to do something, okay? Also, there are some times when either people want to throw things at me, and I'm glad that the cookies are over here so they're not as close to you, or feel like, oh my God, I've been doing this wrong forever, this is the worst, what should we do? Don't panic, we can work through some of these things. So, okay, so we're going to talk about the open meeting law and the public records law. Usually I start this off by saying, what is a meeting and why do I care? And so for kind of keeping in mind the basic rules of municipal government, there's public records, open meeting, and conflict of interest laws in every state. Massachusetts was ranked number 48 out of 50 states with respect to the public records law. Because, anyone know? Because the legislature and the governor are not subject to the law. So they updated the law on a Saturday night in the middle of the night, and you know what they did? They did not update the law to include themselves, so we're still pretty far down. The purpose of that is essentially to have the government's business take place in the public. And the idea is that the government isn't going to do things secretly, that's going to be accessible and available. So there's a presumption under the public records law that any record that you make or receive is going to be public. There's a presumption under the open meeting law that you're going to meet in open session if you're members of boards. And there's a presumption under the conflict of interest law that the town is going to be your number one priority. Not you, not your financial interests or your family members' financial interests. Okay. How many of you all are on boards? Okay, how many staff boards? Okay, all right. So there's a little bit of a difference between what people can do under the open meeting law if they are staff versus members of board. So we'll talk about that a little bit. All right, see, what is a public record and why do I care? When do records have to be disclosed and when can I destroy records? Those are the types of questions that are most typically asked. So what is a public record? The short answer is everything. Everything regardless of the format, okay? So whether it's an electronic record, an email, a plan that someone submits, a document that you get a copy of, and you can look at the definition: books, papers, maps, photographs, recorded tapes, financial statements, statistical tabulations, other documentary materials or data, regardless of physical form or characteristics. made or received by an officer or an employee. Made or received. So someone comes in and they hand you something over the counter, you take it, you put it in your file, it's a public record. And is only not subject to mandatory disclosure if there's a specific exemption that applies. The law looks at the content of the record to determine whether it has to be disclosed. It does not care about the format, okay? So someone will say, oh, well, I sent an email, that's not a public record. Yes, it is. It's a record that was created regardless of physical form. So it can include emails and other electronic communications, even if sent from a personal email account. This is where people start wanting to throw things at me. Or a personal computer, okay? So just because you're working on your own computer at home on a town-related matter does not convert it to a personal record. But the same thing goes the other way. Just because you're working at home on a public matter doesn't make it personal, okay? You want to think about how you're creating records that are town-related, where you're creating them, and what the implications are. If you're creating records at home on your home computer, they're public related to this, not related to stuff that's personal, then those records are public records, and they're actually supposed to either be emailed to a town account. And Robin, I didn't talk to you about whether volunteers have email accounts. Some do and some don't. So if you have one, if you have a town email account, use it for public business, right? If you don't have one, a lot of communities have started encouraging their volunteers to create a Gmail account. So, you know, Board of Assessors member Smith at gmail.com, because then any and all work that you do as a member of the Board of Assessors you can do from that Gmail account. And so it's less likely your personal stuff interacts with your business things. Yes?
But we would encourage anyone who's doing town business, we would create an email, a town email.
Oh, perfect.
So if anyone doesn't have one and needs one, they can just come to our office and we get one.
That's great. After this, you're going to be like having a rush of people. Okay, we're going to talk about that a little bit more. So volunteers and the records they make and receive are not exempt from disclosure under the Public Records Law. That's really important to know. This use of a municipal email address or the creation of a specific email address for your public role can help with records retention. In addition to disclosure of records, the other thing that's required with any municipal record is that it be maintained for at least 7 years or the time that's set forth on the records disposal schedule. Have any of you ever seen that? Yeah. I mean, it's a ridiculous document. It's literally like this many pages. You can search it electronically, which is a lot easier. It has a different schedule for every major department or board. So sometimes it'll say that has to be kept for 30 days or 3 years, and if it says 30 days or 3 years, then it's not a 7-year records retention requirement. But if it's not on the schedule, then it's likely subject to to retention for at least 7 years. So if you're emailing about something related to the town, it is likely, although not necessarily the case, but likely that record has to be maintained for 7 years. And so where should it be maintained? If it's on your own computer at home and a public records request comes in, how is the town going to get it? Only if you go to your computer and do a search, and hopefully you haven't deleted it, or maybe you search in your deleted items, and you're supposed to respond to a public records request in 10 business days after the request comes in. And so, I think it's probably not crazy to think that that might not be at the top of your to-do list. Oh, let me search through my emails for records responsive to this request. And when that happens, if you go past the 10 days, the town cannot charge anything in connection with that request, and it can be a big problem. We'll talk a little more at the end, but if a public records requester goes to court to try and get a record that they've asked for and haven't been provided with, or that they've been provided with but that's been redacted in a way that the court thinks is overly redacted, or if you even provide the record to the requester once they file, the town is responsible for paying the requester's legal fees. So this 10 days is not a joke, it's very serious. And I think one of the biggest struggles, at least that I've seen for town administration, is when a public records request comes in for a board, how to get those board members to search their own emails to get the records. But none of you will take that one, I'm sure. Very serious faces. And it could be that I was very seriously late. Okay. It says could include text messages. I think it is highly likely that text messages will be subject to disclosure under the public records law if they are not already. It is not as clear cut. For those of you who were around in the flip phone days, and I see several people here who, like me, were. Remember, if you wanted to send a text, you had to do like A, B, C to get to C, and so you didn't really text much more than "be there soon" or "I'll meet you at 10" or something like that. Now it's much easier. You can write a whole letter on your phone, and so that's going to make it subject to disclosure. Now, one of the problems that we have is that Verizon and AT&T and whatever the other ones are right now, they don't do a fantastic job of retaining that information. So if you delete something from your phone, it could be that they have it at Verizon or AT&T or whatever for a particular period of time, but there's no guarantee. One of them keeps it for 3 weeks, one of them only keeps the phone numbers but not the content, and there are criminal and civil penalties for improper destruction of public records. So I'll talk about this a bunch as we go through. Think before you text, think before you press send on an email. Is that something you want to have out there? If it is out there, are you going to be embarrassed about it? Is it professional? Is it written in a way that reflects that you're representing the town? And also really be thoughtful about whether you're putting personal information into your into your emails or texts, because it's one thing, let's just say my brother has an accident and someone's interested in that and they email me and say, "Lauren, I hope your brother's doing well. I heard he broke his back." That's terrible. He didn't. Yeah, he didn't. It's okay. If I then get a public records request for that, now I might not have a privacy interest in that text because I was doing it on my town computer, let's say, but my brother might have a privacy interest in the medical information. So we have to redact it. We have to go through it and separate it out versus just thinking we're only going to use our public email address or our public computer for public work and matters related to that. A real life story is there was an individual who during his lunch break would surf the internet in one town that we represent, and when he was surfing the internet, he wasn't exactly staying on the sites that were appropriate. And someone made a public records request for his computer history. And so all the websites that his computer had visited, and it was subject to disclosure under the public records law, even though he was on break, and it was a violation of the town's policy about computer usage for him to be using the computer in that way. He used it like that, and it was a public record. Okay, so you really do want to be thoughtful. Some people, will maybe visit the Amazon website or Facebook or social media. And if you're doing it from the work computer, it can be an issue if a public records request is made for a history of your computer. All right, so how can a person make a public records request? They can make it by coming in to the town office building and just saying, "Can I please have a copy of whatever?" They're not required to identify themselves. They're not required to make their request in writing. Under the old public records law, it was pretty clear that if they didn't make their request in writing, they couldn't appeal. But under the new public records law, it's not as clear. So if someone comes in and says, "Can I have a copy of the Board of Assessors, I don't know, meeting minutes for whatever time, and I'd like this and I'd like that," and they say, "Okay, well, why don't you just fill out this form and we'll get back in touch with you," and I say, "I don't want to fill out a form. I don't have to fill out a form." Okay? Now, if a person doesn't provide their email address or their name and phone number, then it's hard to reach them to say your records are ready or this is how much it's going to cost. So at that point, and I know it seems laughable, but you wouldn't believe the things that people run into. So the best way to deal with that is to say that you'll need to call me 5 days from now and I'll give you the estimate, or you'll need to call me and I'll give you an estimate. I will not prepare the records because I anticipate it's going to be at least an hour of my time, and I'm going to wait till I get paid till I actually do the work. So you can tell them that. Sometimes people write Mickey Mouse or Donald Duck or anything like that, and they can do that. Do you guys keep logs of public records requests, Robin? Yes. So one of the benefits of keeping a log is that even if the individual doesn't choose to write down the request that they've made, you as a municipal official can write it down. So if someone comes in, they ask for Board of Assessors this, that, and that, can write it down and then show it to them and say, is this what you're looking for? Because that way at least you have a correct record of what they want. Okay, records access officer is?
Mary Devlin,
Okay.
and we actually have several in
Like a super RAO and then, yes. I like to think of the super RAO with a cape, so congratulations, Mary, good for you. But basically, requests are supposed to be directed to the RAO. And if you have guidelines on your website that say so, if it says records requests may only be made to the RAO and a request comes in to someone else, it doesn't actually start the clock running on the time frame. But most of us are in the customer service industry as well as in the, in the business of government. And so typically what will happen if someone makes a request to the wrong person is that we would say to them something like, we'd be happy to forward your request to whoever, and the clock will start ticking at that point. They have to respond within 10 business days. That's a change from 10 calendar days. It's basically 2 full weeks of work. Okay, so holidays do not count, but if town hall is closed on a particular day, whether because of weather or anything else, it still counts as a day, as a business day. Yes, Ron?
My understanding is our town is closed on Fridays always, it's not a seasonal thing. The public records did tell me that then Fridays don't count because we're always closed on Friday.
If
It
pub-
might depend on who I talk to.
Yes,
Public
it might.
Records Division.
It may also depend on whether someone chooses to challenge that. I mean, my basic advice to anybody dealing with public records requests is get it off your desk, give them the records, and get it out way before the 10 days. Because, it used to be, and 10 days there's still case law that says 10 days is presumptively reasonable. But the risk is you wind up, and where I typically see the biggest problem from open meeting, public records, conflict of interest law issues is when a land use complaint, a complaint about land is filed in court. They say there's open meeting law violations, public records violations, and conflict of interest law violations. What do you think that does to a judge? Like if your instinct is like mine, you think this judge is not going to like these people. They're going to be upset with the government officials. And it changes the tenor of the work that you do. You're, coming out, you're debating and deliberating over these important things, you're making important decisions, and then it goes to court and the judge wants to talk about whether you posted your meeting the right way or whether you responded to a public records request the right way. It's difficult for a judge to see that all of these types of things really builds and builds on municipal officials, and it's hard to get everything right all the time. But when a judge is looking at a decision that you've made and they're saying, well, they violated the open meeting law and they violated the public records law, it's much more likely, I think, that they're going to believe that you failed to apply the right standard or that you didn't properly consider the evidence in front of you. So you want to minimize those things. And one of the ways to minimize those things is to go above and beyond, to use the best practices. So try not to wait to the day that's the 10 business days. Put it in the calendar right away and see what you can do to get it done earlier. If the response that you're providing does not provide all of the requested records, then a detailed written response is required. So the detailed written response, our experience so far with the new public records law is that if a person appeals a detailed written response, they're likely to get some relief from the supervisor. Okay? Which means that the deck is really stacked against you in that arena. And it's easier to defend what you've done if what you've said is, I looked for everything, this is everything we have, and you're welcome to it, whether you're charging or not. As compared to, and we're going to withhold this piece and that piece and this piece and that piece. Now there's times when you have to withhold either because of privacy or because it protects the town's negotiating position, or there's other important goals that are being protected. But if those things aren't at play, if someone's looking for open meeting minutes, if someone's looking for a copy of a contract, if someone's looking for a document that was used at a meeting, it is much easier just to make that available. We all know that there's pretty much everywhere there's somebody who's really good at the public records law, or really good at the open meeting law in the audience at meetings, and they know just what to ask for, they know just when to ask for it, and it can make it feel like it's aggressive or attacking when those kinds of requests are made or complaints are filed. But I think the best way to think about it is they're entitled to the records, so it's just better to kind of adjust your mindset to think, how can I do what they're asking with the least amount of difficulty for me? Because as you know, if you wait though to the ninth day to get something done on one of these things, you are scrambling at the very end to get it done, and it's a giant amount of pressure, and especially if it's for a person who's a frequent requester, because they're gonna try to poke holes in everything. So if you're able to find the records, and you're able to make the copies, and you're able to give them what they're looking for, fantastic. One of the great things about the new public records law is they've said, if it's posted on the website, and you point them to the place where it's posted, so you say, here's the link, then you don't have to provide the record, a physical copy of the record. So to the extent that it's practical and feasible to post decisions and contracts and minutes, and any other kind of, some applications, licenses, anything like that, to the extent you're able to post those, fantastic, because it makes it much less difficult to respond to requests. And especially for the records access officer who's able to say, the Board of Assessors minutes going back for the last 3 years are available on this, on this website, or at this link. If you don't find what you're looking for, please let me know. That's a response to a public records request, as compared to having to go and find them, having to make the photocopies, having to put them together, having to interact with the requester a bunch of times. You have to list specific exemptions and provide detailed explanations. So it is not enough to say it's exempt from disclosure under the public records law. You have to say it's exempt from disclosure under exemption blank of the public records law because it's looking for blah, 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 and that's protected because it's private. Like, you have to go through the whole process, even more than you used to, and the burden has always been on the custodian of the record to explain, but now it's even more so. And if you're giving one of these detailed responses, you have to also explain what you've done to do the response. So you don't just want to say, we looked and we didn't find anything, because the supervisor will likely say, well, look harder. So you want to say, we looked in the file cabinets, we looked in the computer system, we looked in our, frequent, whatever, files, and we came up with nothing on that. Or to say, we looked in all these places and we found records everywhere, and so if what you'd like is for a particular thing, then let us know what that is, and we can find that for you much more quickly. They want you to show that you're trying to give a full answer. Okay. All right. So the response, we said 10 business days. If you fail to respond within the 10 business days, no fee can be assessed. What do you think? Which types of requests are more likely to be forgotten or not responded to within the 10 days? Big ones or little ones? Big ones. And big ones are the ones that cost the town money. So for example, in one city that we represent, they got a public records request for 60,000 emails. No, 60,000 emails were responsive. They did not respond within the first 10 business days. That's a lot of money that they could not charge. $25 an hour per person that it would take to find those emails, look through them all, and if appropriate, redact them. So in that case, the requester actually just wanted them faster, and so the requester said, I will pay to have you use like a electronic discovery service to try and segregate and everything faster. They did go ahead and pay that cost, but they wouldn't have had to if they didn't want to, okay? So it's really important that there be a response within 10 days. The Records Access Officer is a resource, so you'd work with them to, the Records Access Officer would work with requesters, with the custodians, prepare guidelines to help requesters make informed requests, and those guidelines basically say, these are the types of records that the Board of Assessors has. These are the types of records that the Conservation Commission has. I don't want to pick on the Board of Assessors too much. If a full response, including all the records, can't be provided, then there has to be a written response. You can't just say, I promise I'm going to get this to you in 2 weeks. Have to provide the written response. Amongst the things that need to be included in that written response is the confirmation of receipt of the request, identify the correct custodian, outline what's going to be withheld, and explain why you can't send it within that time frame, and also explain when you're going to provide a response. This is actually the list of things that need to be provided. That need to be in the response. It is very, very significant.
But if you do that, the person is still gonna pay for the full amount because you responded.
So, correct. So the smart thing to do, if you can't do it within the 10 days, and I don't know, Mary, how involved you are in helping with the letters, but basically what you do is you say, we've made this extensive review, we found all of these different things that are responsive, some of them may need to be redacted, but before we're gonna go and do all that work, you need to pay us, and it's gonna take us, you know, X hours at X dollars per hour, and we anticipate this many copies or whatever it is, and upon receipt of a check made out to the town of Charlton, and that amount, we will begin to provide you with the remaining records, or whatever it is. We have always put in that we're not gonna do any work until we get the money. So essentially, it's like a pause in the 25 business days required to be, to provide the records. Okay, but again, it's easier to try and get it all done if it's not a huge request. I never recommend doing the work if you're gonna ask for money and you want the money before you're gonna give the records, and just wait to do the work. Because sometimes people make these outlandish requests and they never come back. So, you know, you say it's gonna cost, you know, $150 and they don't ever show up, and you'll have done the $150 worth of work. But that's something to talk about with Robin and with the RAO, how to deal with it. So initially you do the 10 business days, then you have 15 business days to provide the records, for a total of 25 business days. Okay, so in our view, once you give the estimate, you can wait till you get the money, and then that starts the clock again on the rest of the days. The RAO, within 20 business days, can petition the supervisor for additional time not to exceed an additional 30 business days for quote-unquote good cause shown. So in my example with the 60,000 emails, even if you say you're just gonna spend 30 seconds on each email, we're talking about a lot of work hours. Okay, that might be a good enough reason. The requester can grant additional time, and we have found that this is a much better way to deal with the need for extra time. Now, not every requester is in the mood to be helpful, as you might imagine, but some of them are, they want what they want, and they're willing to kind of talk about how they're gonna get it. So, if the requester agrees that you're gonna work on it for 4 hours a week, and provide copies every Friday for them to pick up, then that's fine. Just make sure you get it in writing, because the requester can allow that additional time. If the request is in writing and it's deemed received on the first business day following receipt, which makes sense. Okay, so if you get it today, tomorrow is day one, for purposes of counting your 10 business days. If you get an oral request, it's deemed received on the day you get it. I don't think there's been a huge focus on that. Fees. The law changed, or the supervisor's regulation changed even before this law took effect, to be 5 cents per page for black and white photocopies, whether it's 1 or 2-sided. Used to be 20 cents a page and 25 cents a page for computer printouts, but no more. Now it's all 5 cents a page. If it's not something that's susceptible to the normal way of doing a copy, so just photocopying, and it's, let's say it's a big, you know, full-size plan or something like that, or it's, you need to dub a tape to be able to redact something, then you can charge the actual cost. The hourly rate is capped at $25 an hour. So, you know, that actually can turn out to be a big problem if only the chief of police is able to do a search and review of records for redaction. Chief of police is paid more than $25 an hour, but it's the chief's actual time that's being spent. The supervisor's office, the new law, that it's capped at $25. You have the ability to ask for more money from the requester, to ask the requester to authorize more. You can do that. If you explain, sometimes they're willing, but the supervisor can also authorize a higher amount. So in my 60,000 email example, if the the city had not been able to agree with the requester about the fee, they could have talked about filing a petition to the supervisor saying this will take us X number of man hours, which would cost X number of dollars, or we could use this other service, which would cost, you know, an IT expert $65 an hour. We'd like to charge us $65 an hour, and the supervisor could authorize that if they want to. Okay. Process questions? No.
So,
Everyone? Yes.
people come in, I'm the building inspector. okay?
Nice to meet you.
People come into my office all the time and ask for all sorts of things.
Yes.
And we give them all sorts of answers.
Yes.
Mostly the right answers, but sometimes they think I'm
I
When
don't
is it
believe
a
it.
public records request, and when is it just them asking a question?
That's a really good question, and the answer is if they're coming in to ask for stuff, for copies of stuff, that's a public records request. Whether you treat it like a formal request or not, as I said earlier, we're in the business of customer service too. So many times someone comes in and they say, can I have a copy of this plan, or can I see this file? And we say, sure, right? And just hand it to them right there. Can I have a copy of the warrant for payment? Can I have this? Can I have that? And we just give it to them. That's a public records request, but we're dealing with it. Under the public records law, questions are not valid public records requests. So for example, I can come in and say, can you explain to me how this works? And you're not required to either make a document to respond to my request or to answer my question. But we do that. So in writing, when you get a public records request in writing, and it might say, I'd like copies of this, that, can you explain why this happened or why that happened? The answer that I always put down is, the public records law does not require that we provide answers to your questions. It does require we provide records responsive to your questions. So if what they're saying is, how many people get family health insurance, we're not required to go and count that up, but we are required to provide them with the records that would demonstrate how many people have family health insurance. Now, sometimes it's just easier to answer a question, right? If we're gonna provide information about family health insurance, that's gonna be, let's just say that's paychecks, and we have to redact home addresses and this and that and names, because we're not gonna disclose whether people have personal or family and whatever. That's a huge job as compared to counting. Oh, we have this many people in our system, that's the answer. But you're not required to do that under the public records law.
So part of that question is her demonstrating that we are responsive to requests. Well, the more paper I shuffle, you know, and I guess it's a decision on my department's part or the customer service part that, well, I can boost up the numbers and say we applied to 600 requests, but, you know, right now it looks like we don't do anything.
Yeah, well, I mean, keeping track of the number of requests you get during the day does a bunch of things for you. I mean, from a purely transactional perspective, meaning when you're going to a town meeting and saying, or to the town administrator and saying, this is what I want for my budget, and you're able to say, we had 600 people come through the office in the last X number of days asking for records, that's a number that's useful. If you have a frequent requester and it's very hard to satisfy them, meaning they're coming in all the time asking for records, and they go to court, there's a defense that we're able to use that says, we're already responding to all of these requests. Basically it's that we're doing the best that we can, but there's so many of these requests we can't keep up. So that can demonstrate that there's a harassing type of request. It can demonstrate that there's, the types of requests that are actually interfering with business operations. So there's a value to keeping track of it. How you want to keep track of it, that it's not required under the public records law for municipal entities. It is required at the state level to keep a log.
Thank you.
Yes. All right. Any other process? Yes.
So I'm in the accounting office, so if I have a department come in and they ask for copies of information that pertain to their department, I would just not consider that a public record, I would just give it to them.
Right.
But I do have some departments that come in and ask for copies of stuff that doesn't pertain to their department, but to another department, and trying to get by with not being a public records request,
Mhm.
and that they're just a department asking,
Mhm.
and trying to get around the cost of the public records.
Yeah. I see this happen in various contexts. My favorite is a city councilor in a city that we represent made a number of requests on her letterhead. And so the response, and demanding it, this should be mine. And the response from the records custodian was, you're just like everyone else, I'll put you in line, you'll get your record within 10 days. Which you can imagine didn't go over that well. But anybody there's a business that the town is running, and that business is gonna operate however it operates. people that make requests that are personal, it's a personal request, it's a public records request. You know, but I think it would be awkward if, you know, someone comes in from the, I don't know, Community Preservation Committee and says, I'd really like a copy of the Community Preservation Committee budget, and you're like, well, that's a public records request, and, you know, as soon as I get your payment in the amount of whatever days. They're wanting it for their public function, as compared to coming in and saying, I want, you know, copies of all of these other budgets. But a little bit, this is, you know, how does it feel? Does it feel right? Really, no one's supposed to use their position to get themselves or someone else a benefit worth $50 or more. So certainly, if it's something that requires some significant work, that's a different thing, and you should think about how to deal with that and maybe talk to town administrator. And I think that's the other thing is that records requests, particularly if they're significant, there should be a discussion with the RA or with the TA, because there's real risk for the town in responding incorrectly, so it makes sense, the RAO, sorry, it makes sense to have that conversation up front. That way you're not kind of scrambling from behind to try and figure out what to do.
Can I
Okay?
ask a
Yeah,
question?
sure.
If a department gets a public records request, because I've had quite a few where it went to the department, CC to me.
Yep.
Does it actually account if it went to them and not to the RAO? Like, we have a form online and everything that should be used to fill out. The first form is for the person requesting, the second form is for the department to provide the RAO with the information they need
Mhm.
to let the person know. People aren't, like, I can tell people they still don't use it.
Yeah.
They'll still go around it and they'll go to the department. Should it even be considered there if they haven't sent it to the RAO directly?
It depends what your guidelines say.
It has to go to the
If
RAO.
your guidelines say that it has to go to the RAO, then really it has to go to the RAO.
So if any department gets one, they should tell them to please
The
use the
best-
form online and send it?
Or to make the request directly to you, because again, they don't have to go online, they could make a request in person,
Okay,
okay?
so they should send it to an RAO so we can do our tracking or whatever and keep track of it.
Yeah, oh, for sure, I mean, at the very least, it should get also sent to you, but if what you have is a requirement that says it has to be filed with you, then it has to start with you.
Okay,
And people should be told that, so when they make an emailed request that's copied to you, the response back could be, thank you for your request, please fill out the form at the following link. You know, yeah, rather than just saying like, we're not accepting this unless it comes in on the internet form, just say, you know, thank you, fill out the form. It's important to us for administrative purposes.
so even if I'm CC'd on it and I have it as a CC, it wasn't directed to me, it was directed to the other person.
Yeah, I mean, if it's directed to you and CC to them,
It's
The
different. Okay.
so, I mean, you know, I think part of this is teaching people that the rules are different, because they always were, you could just make a request to the custodian. And I think it takes a little while for culture to change, to shift.
I wanna go back to emails a little bit to find out if
Okay.
something is actually a record.
Yes,
If I am querying my, members of a board, my board, if they're going to be able to attend in the meeting, so I can post it. To get that response from them, is that a public record?
yep,
You're gonna find that there's people who volunteer for these jobs, even though they're elected, who are going to say, forget it, I'm just not gonna keep
Right.
that kind of stuff.
right now is when I say, I promise I didn't write that law. That's your state rep and state senator. But here's the way to deal with it, okay? As long as you're using a town-issued email address,
I'm using my personal email when I do
you
that.
switch it out. Switch it out, and the reason is because the town servers have backups, and they then maintain the emails, and you don't need to worry about whether you have to keep it or not. So use the town website, the town email address, and all of that disappears.
And I think I'll just stop being, it's just not worth it to me.
Well, what the DA would say, I mean, what the AG would say is,
Put
don't
me in
email
jail.
anyone.
Put me in jail then. I mean.
It is not me, I promise you.
It just seems to be, that kind of email has nothing to do with what's taking place
Yeah.
in the board meeting.
They
that
don't-
we keep records of.
They don't care. They say any record made or received by a government official in their official capacity is a public record subject to mandatory disclosure upon request. Yes, sir, in the back.
The form of the email, response, so someone asks for emails, do you give them printouts?
Under the new public records law, you provide them the record in the format that they want it in. If it exists in electronic format, they can have it in electronic format. If you need to redact it, then, you know, there's some communities, and I don't know if you guys have this, that have like online or computer-based redaction software. Others don't, you print, you redact, and then you, with a Sharpie, once on the original, then you photocopy that, then you do it again, then you photocopy it, and then you scan it in and you can send it to them electronically.
Can I add a piece?
Yeah.
Because we've found that we've had an issue. If someone asks for something, we don't take a Word document and redact it, like highlight in black and then send it to them, because then they can just take the Word document, unblack it, and they see everything you've redacted. So that's also true for PDF, because most people now have PDFs where they can, edit it. So what you wanna do is just what Lauren said, is print it, redact it, rescan it, and then send it.
Also, with the electronic document, there's a history of changes. They can go back to the history of the document and just go back to the undo part that they want to go to.
Yeah, so just one sec, so in my experience too, if you just do one photocopy and then redact and then scan it, then you print that out, you can hold it up and you can read the text through it. So you wanna actually do it twice. You redact once with the Sharpie, photocopy it, redact it again, photocopy it and scan it. Okay, yes,
That's what I was gonna say.
okay. Really?
Yes.
Okay, yes,
You have the abatement application?
yes,
After a decision has been made, is it then public?
never.
Never.
Abatement applications are never subject to disclosure. So there's certain exemptions that are very common. Exemption A is the statutory exemption. It basically says that there's a statute that's exempt because the law says it is, or because the law says it can only be disclosed to a certain limited group, then it's exempt from disclosure under exemption A. So the way I usually say is like exempt from disclosure under the open meeting law as it operates through exemption A, or under the Corey law as it operates through exemption A. So here's some examples. The Secretary of State has a booklet online, a guide, public records guidelines maybe, a guide to public records, and at the end they have a summary. It's not everything, but a summary of the exemption A statutes. Okay. The other thing is that on the Attorney General's website there is a FAQ on the open meeting law page about how boards of assessors should deal with abatement applications in executive session. Okay. Another exemption that's commonly used is exemption C. Exemption C has two parts. The first part is personnel and medical records. Those are always exempt from disclosure. What do I mean by personnel records? I do not mean what you think I mean. What I mean is records that are evaluative in nature about an individual are considered to be personnel records. So not whether you came to work or you didn't come to work, not whether you have 10 sick days or not 10 sick days, not whether you were late or early. That's not going to be something that's exempt from disclosure. However, the town administrator's evaluation of you, or a thank you note that someone sent to you, or a reprimand or something like that, none of that is going to be public. Anything that's relevant to hiring and firing, okay, can be withheld. And then medical information, it doesn't matter about who. So if it's medical information about a person, not just an employee, then it's subject to automatic withholding under that first clause of exemption C. No balancing test, okay? If it's medical, my brother's back, that's exempt from disclosure. However, under the second clause of exemption C, and you can see where that semicolon is, any other materials or data relating to a specifically named individual, the disclosure of which may constitute an unwarranted invasion of personal privacy, that requires you to go through a balancing test. Does the public's right to know outweigh the individual's privacy? Okay, so typically the case law says that these are intimate details, highly personal in nature. Whether someone has government assistance, whether they're married, whether they're divorced, whether they're paying alimony, other stuff like that. Okay, whether they had drug abuse problems. Exemption D is actually a very useful exemption for the work that we do. Exemption D allows us to withhold intra-agency memoranda or data during the pendency of a decision. So for example, if you are a staff person for a board and you write your analysis of what you think the facts suggest, you know, I reviewed this and I think X, Y, or Z, that can be withheld from disclosure until the board makes an actual decision. Okay? In addition, if you get a letter from your town council that analyzes something, that can be withheld from disclosure. If you get a report from an analyst on facts, so the first part it'll say like factual determinations, and the second part says recommendations. The facts will likely be a public record. when the report is done. But the recommendations won't be a public record until the board acts on that, okay? So whenever I'm looking at reports, and this is something to keep in mind, when you are asking for someone to do a report for you, ask them to put the facts separately from the recommendations, because then you don't have to go through and redact the recommendations from within the facts, okay? So this is like groundwater stuff and whatever, and then this is what we should do about it, or what I'd recommend you do about it. Well, the groundwater facts and findings are public, but the recommendations about what to do about it won't be public until the Board of Water and Sewer Commissioners decides how to handle that, okay? The other thing that's really cool is if you're working with another municipality on something, and you're exchanging information with the other municipality, that can also be withheld until a decision is made. So that's kind of cool. All right, next, exemption E. This is one people like. This is the notebook exemption. This means if you take your own personal notes and you are not the clerk of your board, you're not the minute taker for your board, and you're taking your own personal notes as a board member during a meeting, and you don't share them with anyone else, then they stay private to you. You don't need to retain them. You don't need to disclose them if a public records request is made. If you are the clerk of the board, like, you know, 3-member board of assessors, and you're an assessor, and your job is to take the minutes of the meeting, then your minutes, your notes, are public records as of the moment of their creation. So the important information here is don't share your stuff with anyone else. Like, don't push your notebook across the table and be like, right? Don't you think? Because as soon as you do that, you've now made that public, okay? If you're the minute taker, you don't want to make snarky comments about anyone on the side. I wish she would stop talking, because that's a public record. And it doesn't matter whether you take shorthand, or you write in German, or you know, have the worst handwriting known to man. As soon as you take those minutes, they're public records, okay? And so someone can come in right after the meeting and say, can I have a copy of that? And the answer is yes, not, oh, sorry, they haven't been approved, you can't have them. It doesn't matter that they haven't been approved. Your actual notes are public. So what do? Put a big draft on the top of it with the date, okay? Because then it's clear, yeah, the board couldn't have possibly looked at those because the meeting was last night and this is this morning, and, you know, they had the date right on them. So draft, and don't just write it on the front, write it on every page, front and back, and use a color if you want it to stand out. Okay, exemption, so this means for those of you who might share calendars or anything like that, as soon as you share your personal information, your personal calendar with others, it's a public record. There's a very high-placed Massachusetts government official who learned that a very hard way. They still have the ability to redact personal information, but the fact of sharing makes it public. Okay? Yes?
Is that true if you're sharing your calendar with your administrative assistant?
Yes.
In your office?
Yes. So don't put your personal stuff on there. That's the way to go with that. Otherwise, if you do, then you have to redact it. And again, this is one of those things where it's easier if you don't have to redact. That's just what it comes down to. All right, exemption F, and I think only part of it is showing there. Exemption F allows withholding of investigatory materials necessarily compiled out of the public view during the pendency of the investigation. That's one thing that it does. And that's really important. It's important for law enforcement. It's important for a building inspector if they're the zoning enforcement agent. It's important for the fire chief when they're doing fire investigations. And the Board of Health when they're doing health-related investigations, okay? Also, if the Board of Selectmen is like a licensing authority, then it's important for the Board of Selectmen as well. During an investigation, the records relating to the investigation can be withheld, because if we had to disclose them, that would make it easy to avoid getting caught, right? You'd know exactly what they found, and so no problem. The other thing that this does, which is very important, is it also allows the names and identifying details of voluntary witnesses and complainants to be withheld indefinitely. Why? So people can come forward and talk to enforcing agents without it being a loss of their privacy. So the example I like to give of this is in one of the towns we represent, there was a major fight in the middle of the street. There was a number of pictures taken. The police interviewed the people that were in the middle of the street. And because of the way they saw things, this picture that was on the front page of the newspaper, you could actually read the description that the individual witnesses had given and just know exactly who the person was in the picture. So, they were able to withhold the entire police files even after the matter had been resolved, because, even after the investigation had closed, because the voluntary witnesses and complainants, there was no way to redact enough information from that would have protected their identities. Okay?
So, can I am the
Yes.
zoning enforcement.
Yes, oh, this is lovely.
This is the follow-on question.
Yes,
Neighbor comes in.
yes,
Wants to complain.
yep,
I wanna remain anonymous.
yep. It's
Okay.
very difficult in those circumstances for someone to remain anonymous, especially if what they're complaining about isn't visible from the street. That's what it comes down to. So in those circumstances, the only thing you can say is, look, I can try, but it's not a guarantee. Because there's no way that I can investigate this without saying it was observed, and the only person that could have observed it was you. And sometimes they don't want that, and they'll leave. On the other hand, if let's say the Board of Selectmen gets a complaint, you know, that X, Y, or Z event happened, the board can say, oh, we're gonna look into this, because it's a bigger event, so it's easier to look into it without identifying the individual. Okay? All right. Exemption N is a post 9/11 exemption. You like my marauding cyber stealer there? It allows a records custodian who believes that disclosure is likely to jeopardize public safety to withhold a record. Now, that is very different than every other exemption. It wasn't written by the Secretary of State. He didn't get to comment on it before it was passed. This essentially makes it seem like you need to ask some questions, right? Because how do you know if it's likely to jeopardize public safety? So, since you're not allowed to say, why do you want this, you have to say something like, under the law, if I'm not convinced, if I'm not sure whether this is gonna jeopardize public safety, I can't allow it to be disclosed. If you wanted to give me more information about what you're looking to do with the with this record or whatever, then I'd be happy to make a different finding. Okay, the other thing that this allows to be withheld, which is very useful, is municipal infrastructure, and your emergency response plans, including cybersecurity emergency response plans, so that's a very useful thing. Exemption O allows withholding of the personal email and the home address and home telephone number of an employee of a municipality that maintains those records identifying people in that category. However, if you are interacting with the government for something, you're not guaranteed that your email address will stay private. Okay? So again, back to your question about, do you want to use your municipal email address or a private email address? If the municipality is working with you and has offered you a special email address and you wind up emailing other people and a public records request is made for the email address, this is your personal email address but you're using it for public purposes, it may be that someone else's someone else could provide a copy of a record sent from your email address and the town wouldn't think about withholding it because it's part of the official record. So it's another reason to think about that. And especially for public safety, the exemption that already existed continues to exist. If you live in and work for the town, your name can even be redacted from the street list, your home address. And those are your family members. The new public records law exempts from disclosure records divulging or tending to divulge the names and addresses of those owning, possessing, or licensed to own or possess firearms or ammunition. And it adds personal email addresses to law enforcement withholdings. All right, appeals. This is what we started off talking about, so I was trying to impress upon you how serious the public records law is. You can appeal to the supervisor of public records now who has to come up with a decision within 10 business days. If they're dissatisfied with the supervisor's decision, the requester can appeal the decision to Superior Court. The Attorney General can appeal to a decision to the Superior Court, and the requester can also just go directly to Superior Court. They don't have to go to the supervisor first. This concept of exhausting your administrative remedies does not exist for public records law issues. In court, there's a presumption for award of attorney's fees if the plaintiff is successful, even in part, including if once the suit is filed, we give them the records because we don't want to fight about it anymore. And I like to say, I'm sure your town council is very reasonable rates. If you think about what a Boston attorney, even like at a private, a private sector firm is charging, it could be $800 an hour, $1,000 an hour. if it took someone 10 hours to write a complaint, the town could be on the hook for all of that. If the person had to come to the courtroom and argue, you could be on the hook for that too. So it's really important to try and avoid that. In addition, I didn't put my insult to injury slide up here, but there can also be a penalty, a civil penalty assessed upon the town if a town is unsuccessful in a lawsuit. And the other thing that can happen is that the town can be ordered to provide those records at no cost. So let's say you say they're not public, we're not giving it. Now, not only are you paying all of those other things, but you're also now investing the money, because that's really what it is, in personnel, time, and effort. The electronic records preference that I mentioned earlier is a tool to try and use. And that tool, essentially, if you're able to post these things and someone comes and makes a public records request for them, you can just point them to that. Minutes are a huge deal. I don't know if you guys are as up to date as you can be, but that's so important. People always are looking for minutes, and that really reduces the work that you have to do to get responses. Best practices, use your town email account. Deliver any records created outside of town hall or off of town hall servers to the town hall. So that's the option. If you're not going to use your municipal email address, then you could either copy a municipal email address, so you could have like Board of Assessors at charlton.ma.us, and you could just copy that email address every time you go to email related to town business. Again, that's going to put it on the town servers. Or you can print off everything that you do at home and you can bring it in. So just like you prepare for a meeting, you look at the meeting agenda, you look at the packet, you print out any of your emails from the week before, and you bring that all to your meeting. That's the other option. This is one of my cheats that you must always think about. Be comfortable every time you press send with reading that email on the front page of a newspaper or on a blog, hate blog or otherwise, and or that it's going to get forwarded to people that you didn't anticipate. Okay, you represent the town, whether you're an employee of the town or you're an appointed or elected official of the town, and it matters. I have gotten emails that I would say are not quite at the professional level that one might hope, and I always think to myself, thank goodness that they're emailing with counsel. Because if they weren't, their records would be subject to mandatory disclosure. There's nothing private about it. They made bad word choices. They talked about someone else. That's not good as a matter of practice. It's not good to talk about public records requesters in a negative way or open meeting law complainants, especially if a board is having a problem with an individual. It's tempting to write about that individual. Think about it. It could get forwarded to them. Okay? So you really want to be thoughtful about that. Try to keep your personal and your professional separate. Don't ask about someone's brother's well-being, even if you know they hurt their back, in the same email that you're conducting public business. Email back separately a second later. You can do that very easily. Put personal in the Ray line instead of having the business Ray line. Okay? Use a formal tone. Avoid asking for or providing personal information in town emails, including unpublished telephone numbers, medical information, social security numbers, financial account numbers, and the like. Don't ask for personal information if you don't need it. And that's something that a lot of towns have started to look at their forms again. Like, is this information something that we need? Because if you don't need it and a request is made for it, you have to redact it. So now it takes more work to respond to the public records request than if it didn't have it in the first place. Okay? Consider whether a formal record is required. One of my best moments giving a public records law discussion was when a town manager stopped me when I got to this and she said, "People, the phone still works." And it's true, you kind of forget. You're used to doing everything by email. If something could be misperceived or misunderstood, and sometimes email isn't the greatest way to convey emotions, as we know, pick up the phone and make a call. Because then you haven't created a record that's subject to disclosure. And I'm not saying that you should avoid creating records to avoid having to respond records in response to a public records request. But not everything has to be written down when you could accomplish it with a phone call. All right, that's that.
So if I phone all my board members and to find out if they want to be at this meeting, that's not a public record then?
Correct. But I will talk about the risks of those phone calls as we go forward. Because there are risks. There are risks in emails too.
And if I have a meeting and somebody requests the next day for the minutes of that meeting, and we're not meeting for another month, to actually approve those meetings as
The minutes.
valid, right, the minutes, I clearly can't give them that document until it's approved.
No, you have to give it to them. Minutes are public records as of the moment of their, the draft minutes are public records as of the moment of their creation, even though they haven't been approved.
Okay. So we
You
don't
just
have-
write draft on the top of them
Okay, so-
and the date.
okay.
Yeah, you have to. Okay, yes.
Just to go back, because you mentioned this a little earlier, and just before you went on, you mentioned, okay, you may have notes in shorthand.
Yeah,
Someone requests those notes.
Yes.
You give them to them in shorthand, do you
Yeah.
have to translate?
no.
Thank you. If it hasn't been already translated.
You don't have to make a record in response to a request for a public records request. If it doesn't exist, then you don't have to create it. But there are times when it's easier to create it than not. One of the requests we've seen throughout the state is from this contracts information group, and so they've asked for like 25 data points. And really, you could go through all of your contractual records and invoices and come up with all of the copies of the records that would give them the information they're asking for. But it's really just much easier to count them up and make to give the answers to the questions. You're not required under the public records law to answer the questions. You're not required under the public records law to create a record, but you're not prohibited from it either. So you have to use your judgment about which is a better way to deal with that request. All right, so the open meeting law, what types of meetings, what rules need to be followed, and what are common violations? What is a meeting? Now, again, I did not write this law. It's another middle of the night thing in a closed session. It's not my fault. One of the rules that is most annoying to a lawyer is you don't use defined terms to define other terms, because then how on earth do you figure out what the term actually means? But this is the open meeting law, okay? A meeting is a deliberation amongst a quorum of a public body, okay? Those are all defined terms to discuss matter within the jurisdiction of the body. I like to say that the easiest way to remember this is a meeting is when a majority of members talk about anything that relates to the public body, to the business of that body. Okay? Just think about it in the broadest way that you can, and then you'll have gotten it right. All right? Deliberation, an oral or written communication, this is new, through any medium, including electronic mail, between or among a quorum of a public body and any public business within its jurisdiction. Any type of communication, whether it be email or a phone call or a text amongst a quorum about something within the jurisdiction of the public body. If you think about it like this, the Conservation Commission's jurisdiction is going to be limited to wetlands type things. The Board of Selectmen's jurisdiction is going to be limited to more things because they're responsible for more things. Okay? But do you think the Attorney General would like to hear from the Conservation Commission in defense to an open meeting law claim? Oh, it wasn't a violation that all 5 of us got together to discuss X, Y, or Z, because that's really not within our jurisdiction. No. If it relates at all, it's going to be considered within the jurisdiction. Okay? So you want to be really careful about that. Oral or written communication. So we'll talk about that in a second. A quorum is a majority of the members of the board. Not the members that have been appointed or elected, but the whole board. Except in very limited circumstances. In fact, the Conservation Commission, when acting under the Wetlands Protection Act, a quorum is a majority of the members then in office, and that's it. That's really the only example. All right? A public body. A multiple member board, commission, committee, or subcommittee within any town, however created, elected, appointed, or otherwise constituted, established to serve a public purpose. A private 501c3 is not a public body. Okay? But pretty much any other multiple member body in a town is going to be subject to the open meeting law. And a subcommittee of that body is going to be subject to the open meeting law. There's a few little exceptions. We'll talk about them.
A quorum of 6 members, what's a quorum?
4.
It has to be 4.
You have 6-member public body, you need 4. Is it Board of Library Trustees?
Yeah.
Because that's one of the only ones that has an even number.
It's,
Okay, so there's basically 3 major issues. The first is notice, timing, no less than 48 weekday hours prior to. You have to have that notice posted. Location, has to be posted in a location accessible 24 hours a day. Is that your website? Yes. And the meeting has to be held in an ADA accessible location. Okay. What does this mean? I always have someone raise their hand, I wanna help you before you do. And say, well, we'd love to get wine together at my house for our meetings. No, you may not do that. Because unless your house is accessible to the public and handicap accessible, you can't meet in a private house. Okay? Could you meet at a hospital? Yes, if the hospital is open to the public. Could you meet at a nursing home? Yes, if it's open to the public. Could you meet at a church? Yes, if it's open to the public. Okay, it doesn't have to be a town-owned building, but it has to be handicap accessible and open to the public. If the front door is locked and you can't get in unless you're invited, it is not open to the public. You think I'm joking, but I'm not. And if it's a building that would otherwise be open to the public, like a school building, and you have someone at the door when the people are supposed to come holding it open, and then when everyone that you think is there that needs to be comes, you walk away and close it, it is now not open to the public. Okay, so it has to be open to the public. All right. The level of detail. We're going to talk a little bit about this more, but it has to be a specific list of things that will be discussed. It used to be more akin to a town meeting, right? Actually, what it used to be is time, date, and place, and the board, and that was it, okay? A lot of towns would have something up there like minutes, reports, public hearing, executive session, right? And that's kind of like town meeting, right? You say, here's the brief version of what we might talk about, and anything that's related to it's going to be okay to discuss further. Because people are on notice, they know. The Attorney General does not interpret the law that way. The Attorney General, even though the statute says a list of topics, the AG says it's a list of items. So a topic, fall soil permits. An item, fall soil permit application, 1 Main Street, Smiths. Okay, that's a very different level of detail, and it is the second level of detail that they require. Okay? Can't just say appointments, you have to say the people's names if you know who they're going to be. And if you don't put it in the meeting notice, then you have to say exactly where it can be found. It's very hard to win a case against the Attorney General's office in the open meeting law context, but we actually were very lucky to win one where the AG had said that it was fine to do that as on file with the Board of Selectmen or click here for 1 meeting notice, because on that day the board was very crowded, the meeting board outside the clerk's office. But a different day, same exact thing, it wasn't okay because the board wasn't crowded. And the court said, no, you can't, it's not that thin a line that makes it okay versus not okay. But the idea is that people can look at this and know what's going to happen, all right? Avoid shorthand references, I'll talk about that. All right, purpose. There's a presumption, just like there was under the public records law, that every record made or received is public. There's a presumption under the open meeting law that every discussion is going to happen in open session, okay? No matter what, even if all you're meeting for is an executive session purpose, you still have to open the meeting in open session. And the AG has now said that the meeting notice has to say, number 1, open session. Number 2, executive session with the purpose listed. There's only limited authority to meet an executive session. When you meet an executive session, you have to follow the rules. Otherwise, the AG will say that's a violation of the law. And just for those of you who are not as lucky enough to experience it, under the old version of the open meeting law, where the local DA was the enforcing authority, typically they would say something like, we're very pleased that upon receipt of a complaint alleging that the board entered executive session without taking a proper vote, the board met again, discussed the possible error, re-voted in the correct manner, and vows to never do this thing again. And the DA would say, we very much appreciate the board's efforts in this regard and look forward to working together in the future. Now the AG says that tiny little thing was a violation of the open meeting law. And if you do it again, it'll be deemed intentional. Now, I'm not saying that either approach is the right approach, but I am telling you what before was a collaborative kind of, we're going to get through this together. I think that had to do with the fact that the DA knew a lot of the people in the community. The AG doesn't know anybody, they don't know if one board is really trying versus another board not really trying. They don't know if the person making the complaint is gonna find fault no matter what versus a person that's making a complaint for the first time, although obviously they see the same names. Anyhow, the point is, if you're gonna use executive session, you have to follow the rules. And it's very rare that executive session is allowed, except if there's litigation, except if you're a board that's looking at the value of real property, except if you're the board of selectmen or other appointing authority dealing with discipline or dismissal. So just bear in mind, open most of the time with a lot of detail. The minutes. Under the new open meeting law, the minutes have to be much more specific than they were under the old open meeting law. The way I like to describe it is, let's just say that this was a meeting for purposes of the open meeting law. The minutes under the old open meeting law would say, Attorney Lauren Goldberg attended the whatever meeting and gave us a presentation on the open meeting and public records law. Several questions were asked. That would have been enough. Under the new open meeting law, Lauren Goldberg presented a slideshow. The slides are attached. Lauren described the obligations under the open meeting law, including ... and ... Sir, the person in the back had several questions about X, Y, or Z. Lauren replied blah, blah, blah. So it's completely different. It's not supposed to be a transcript, but it's also supposed to be sufficiently detailed that someone else reading the minutes knows what happened. Now, in this one, I actually do have a position, and my position is, if someone really cares about every word that was said at the meeting, they should come to the meeting or watch it on TV. But that's just not how the world works right now. And so, for those of us that are used to the old rules, this feels burdensome. And I think the reason it feels the most burdensome is because, and I'm sure some of you have experienced this, if I talk for 15 minutes, and the person who's taking the minutes kind of liked what I had to say, and they wrote down a lot, and they were like, wow, that's really thoughtful. And then the next person that got up, like, didn't say things that were thoughtful, or the person didn't think they were thoughtful, and so they wrote, so-and-so person got up, and they rebutted those comments, and were very annoyed. But that person talked for 20 minutes? Now, the conversation at the table with the minutes, as you know, is, I spoke for 20 minutes, and I had 3 lines, and she spoke for 15 minutes, and she has 75 paragraphs, and that's not fair, and my comments were just as important, and besides, I don't like how you characterize my comments, and blah, blah, blah. I used to say under the old open meeting law, skip all that, just give a summary, because you don't want to get into a he said, she said, this one said that, because people are going to fight about it. But now that is a requirement of the law.
So, at a meeting like tonight,
Yes.
if there's a quorum of the board present,
Yes.
and as a staff member, we have to take, if there's no discussion or no votes taken, we still have to take applicable minutes. If there's
Oh, you're going to love my answer. Here is the lawyer answer. Ready? It depends. All right, we're going to talk about that in a second. All right, meetings. Provided that no opinions of a governmental body are expressed, attendance or distribution amongst a quorum does not constitute a meeting or a deliberation. So you can distribute to a public body a meeting agenda, scheduling or procedural information, reports or documents created by somebody other than a board member. And as long as the materials don't express feelings, ideas, beliefs, and concerns. You're going to hear me talk about that a lot. Feelings, ideas, beliefs, and concerns. So, if you're the chairman of a board and you want to schedule a meeting, it is not a meeting to schedule a meeting. Okay? You just can't talk about your feelings, ideas, beliefs, or concerns. You can call each member and say, are you available on Tuesday? Are you available on Tuesday? Are you available on Tuesday? What you can't do is say, because it's very important to me that we deal with this as soon as possible because this issue is critical to our mission. Because that second part is feelings, ideas, beliefs, and concerns. Now, in theory, with a 6-member board, you could say that to one person without violating the open meeting law, because it's not a quorum. But on a 3-member board, it's pretty quick. The second you say, I feel you violated the open meeting law. And even with a 5-member board or 6-member board, it's kind of easy to slip into, because I think this is important, because this, because that, I wish, I think, I feel, I believe. Those are words that as soon as you hear them, you should, as soon as you think them, I cannot write that down, okay? It's one thing to write to the chairman, to email the chairman and say, Mr. Chairman or Madam Chairwoman, would it be okay to include X, Y, or Z topic on the agenda next week? Or would you include that on the agenda next week? It's another thing to say, because I feel like this is really important and we need to deal with it as soon as possible. As soon as you get to the because I feel, that's part of a deliberation if it reaches a quorum. So if you email all the members and say, are you free on Tuesday? And someone writes back and says, Tuesday works well for me, and I think blah, 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 and you've replied to all, violation of the open meeting law. Okay, so the AG says, don't use email. And I say, yeah, okay, in a perfect world, that makes sense. But if you're going to use it to do scheduling and things of that nature, don't reply to all. That is a simple way to solve the problem. I like to think of reply to all like a big red flashing button. Don't press it unless you really, really mean it, because bad things happen. Reply just back to the person that sent you the comment. I mean, that sent you the email. Don't reply to all. Some towns I know, if a staff member is sending out something, so staff members aren't subject to this, I wish, I believe. Staff members can say whatever they want. But the risk is that your board members reply. So you could actually, if you're a staff person, you could actually put right in there, please do not reply to all. This is for preparation for Tuesday's meeting only. You can do that, okay?
But what if they do reply all anyways?
What'd you say?
What if they reply all anyways?
If they reply all with, I think, I feel, I wish, I believe, that's a violation of the open meeting law, and your response should be, do not respond any further. This is a violation of the open meeting law. I'll put this on the agenda for whatever's meeting. And at that meeting, you say, inadvertently, so-and-so replied to all. I'd like to just make sure that we ratify, validate, and confirm any action that could have been perceived to have been taken by acknowledging that such and such person thinks this is really important.
What if we just send it to the chair and blind copy the other members?
I am a fan of blind copying. However, I'm a fan of blind copying only if you say you're blind copying. So it would, and you could just blind copy everyone. You could say, dear board members.
Hello all, dear board members.
That's right.
And they-
All board members are copied on this email. Yep. But to ensure that we're avoiding violations of the open meeting law, I have blind copied you all. Yep. That works. But again, the fact that that email is a public record, and with emails, the entire envelope is a public record. So not just, when it's received, if I receive it and it's just addressed to me, it looks like it's just to me, but in fact, your sent item is a public record, and that'll show who it got sent to. Okay, attendance at an on-site inspection. How many land use type words do we have here? Oh, one person. On-site inspections are not subject to the open meeting law. Why do you think?
Not ADA.
They're not ADA compliant.
And not open
That's-
to the public.
Yep, they're not open to the public, and they are not ADA compliant, not open to the public. That's the two reasons. We can't make someone who wants to file an application open their property to the public. Okay, but all the board members can go at the same time. Now, this is when I say, and same thing with the next one too, attendance at a public or private gathering or to post a meeting of another body, where you need to know your board. Okay, now sometimes we have boards where people are not good at keeping their opinions to themselves, right? So if you have a board that's not good at keeping their opinions to themselves, then you're not going to plan an on-site inspection for all of them at one time. Because what is going to happen? They're going to deliberate when they're there, and they're not allowed to deliberate. Deliberation is, I see, I think, I feel, I wish, I believe, whatever it might be. So I use the Conservation Commission for this because let's just say that this is the buffer zone and there is a number of cut branches in the buffer zone, okay? And we all know that's a violation, bad behavior. So we're there on the site inspection, and I look over and I see that. I can't say, oh, that's in the buffer zone violation, because that's, I can say, I'd like to please note that for the record. Okay? Now, if there's a group of big talkers, and I'm picking on the Conservation Commission apparently, and we know that the Conservation Commission cannot, and again, this really isn't about real people, cannot keep their opinions to themselves, they should not all go at the same time, because they're going to turn and say, Bob, don't you think that's a violation? I think that's a violation. That's a buffer zone, right? Do you think that's a buffer zone? That's definitely the buffer zone. Totally a violation. That's a problem under the open meeting law. Okay? What should you do? Everybody keep their own notes, not part of the government file. As long as they don't share them, they don't have to make them public. And schedule a meeting for immediately after at town hall or wherever the right place is. And then come in right then and share your feelings, ideas, beliefs, and concerns about what you just saw at the site visit. Okay? All right, attendance at a public or private gathering or social event. This is in response to actual real problems where people would be invited, like, to a senator's office at the State House. They're not invited to go and deliberate, they're invited to go have their senator be able to talk to them. So this is kind of dealing with that. It's also dealing with parties, social events, or like an opening, like a school ribbon cutting ceremony, something like that. What I like to say though is, if we're talking about best practices, you want to be thoughtful, okay? If you go, I went to a party in a lovely town in Western Mass, and as I walked by the kitchen, I look over the entire Conservation Commission, for real, was in the kitchen, all huddled around the table. And I'm thinking to myself, that couldn't look worse, right? And immediately came to my mind the game of Clue. You know, it was the Conservation Commission in the kitchen with a knife. You don't want to put yourself in a situation that makes it look like you're violating the open meeting law, because really, for the purposes of a complainant, they can just make the allegation even if it's not true, okay? So don't do that if you can avoid it. Don't have a party just for the Conservation Commission. That's going to look bad. And what are the chances that you're not going to talk about ongoing business? They're not high, okay? So be careful about that. Don't put yourself in a situation where it looks like that. But if you all wind up at the same party, you don't have to leave. When I went to one of the first meetings where I was the only council, there as town council, I am at this meeting of a board of selectmen, and we're meeting with one member of a board, and in come 3 out of the 5 of them. And I'm sitting at the table, this is in the year 2000, thinking, what am I supposed to do here? Am I going to tell someone they have to leave? And I decided that yes, I was going to tell someone they had to leave, which under the old law they would have had to do, okay? Under the new open meeting law, and this is the difference here, you don't have to leave if you show up and there's a quorum of your board there, okay? But you can't deliberate when you're there. So let's use the Board of Selectmen and the Planning Board as an example. Planning Board meeting about a very controversial thing, and the Board of Selectmen wants to weigh in. If the Board of Selectmen wants to weigh in as a group, they should post their meeting and hold a joint meeting at the same time. Doesn't mean the Planning Board has to approve of them being there and having a meeting. It means that they should post for the same time, and that way, if the board weighs in, then it's not a problem. They haven't violated the open meeting law. Compare that to one member of the Board of Selectmen shows up at that meeting, gives a statement, I'm a selectman, but I'm not here as a selectman, I'm here as an individual, and I think blah, 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 blah. That's not a violation of anything. Let's also say that 2 other members of the Board of Selectmen come in and they sit in the back, and they turn and they say, and again, totally hypothetical, don't you think? Don't we blah, blah, blah? Now, we think, we feel, we believe, we this, we that, deliberation, problem under the open meeting law. So this is a know your board scenario. If your board is likely to want to talk about things, no, Bob, we didn't say that. Yes, you did. No, we said blah, blah, blah. Isn't that right? If they're going to do that, then post for them, okay? If they're going to get up and speak as individuals and they're going to be able to not talk to those other members, then don't worry about it, okay? So it's definitely a know your board. Now, for all of these things, best practice, don't drive together, don't sit together, don't whisper, no whispering. Don't have a confab in the hall right before or right after. It's just best to know that people are watching you, and you don't want to create the appearance of a violation. It's very important that that be the case if there's a possibility that the matter could come before that other board, right? Let's say it's something that might eventually make its way to you, you as a board. Well, you don't want to look like you prejudged. You don't want to look like you participated and try to affect the result at another board. So you want to be really thoughtful about that, okay? In terms of whispering, that's not even okay at an actual meeting, just so you know. 5-member board, 1 member here leans back to talk to the chair, leans back and says, Mr. Chairman. This person leans forward so they're not in the middle of the conversation. This person says, I really need to use the bathroom. Can we have a break? And the chair says, of course we can. DA, violation of the open meeting law. Because a quorum was having a discussion in secret. Okay? No whispering. No passing of notes either, also a violation of the open meeting law. All right, okay, we did that.
Can we go
Oh,
back one, a
yes.
couple slides ago, when I was looking at it?
We can't go back, no, I'm kidding.
No,
Okay.
you don't have to go back, I just tell you what it is. It said here on, notice, location must be posted in a location accessible 24 hours a day.
Yep,
Maybe I misinterpreted that. The meeting doesn't have to be accessible 24 hours.
no,
Just
the notice for the meeting, yep.
Okay.
Yep. All right, so avoid creating the appearance that you're discussing municipal business. Post immediately after. If you wish to speak at a posted meeting of another body, make sure you say you're speaking as yourself. But you can get up and you can say, you know, I am a member of the Board of Assessors, but I'm here tonight as an individual. I'm speaking in my personal capacity. Very important not to represent the board unless you've been authorized to represent the board. And that's a vote of the board to say, you know, Lauren, go to that meeting and represent us at the meeting. Okay, you speak for the board. Okay, and then if you can't control the board, or the board cannot control itself, then post a joint meeting. I mean, what people always say, well, what do I put on the meeting notice? You can just say to listen to and perhaps, you know, comment on matters pending before the planning board as follows. And then whatever their agenda was. Okay? Email. Email specifically addressed in the open meeting law. Used to not be, now it is. There was only one DA that thought that email exchanges weren't subject to the open meeting law. Now the AG says they all are, and the law says it. A quorum may not use email to share their ideas, feelings, beliefs, or opinions, whether serially or in a single email. So if there's a 3-member board and or 5-member board and I email one person, not automatically a violation of the open meeting law, but if one of those people emails a third person in the board, now that's 3 people that know feelings, ideas, beliefs, and concerns, violation of the open meeting law. Same thing with serial telephone conversations. So in the explanation, or the example you gave, oh, I can just call them. It's true, you can just call, but you can't talk about substantive matters because it creates a violation. Okay? Yes?
So, what I get often from some of the boards is the chairperson will email me with their thoughts and concerns, and then they will CC all of their board members and all of my board members. Is that
No.
a violation?
Yes. Cannot CC all the members of your board. Not a violation to copy all the members of your board. If one of your board members responds, then it is a violation. Okay? So,
Can they then email me, my board members as a CC, and then after they send that, then can they send that email and forward it to their board?
no. Nor can they send like if they do an analysis of why all these things are a problem, they can't send out their analysis to their board members. They have to have that discussion at a meeting. As compared to you, Robin, saying, I've analyzed this and I see these problems, you can send that out. Okay? The big problem is the responses. If it's something within your jurisdiction, and this happens all the time, sometimes on purpose, in my experience, and sometimes not, a member of the public will email all the members of a board with the hope that someone will reply to all. Because as soon as they do, it's a violation of the open meeting law, and that same person will then go and file a complaint. Because they know it's a violation. So a lot of towns have started using adopting a policy about how to respond to constituent email for that reason, meaning it gets sent, you know, if it gets, do you guys have this, like a Board of Selectmen address on the, that goes to all members of the board?
No, we have
Okay.
a group that the staff uses, but.
Okay, so, you know, either they add them all together or something, and so that you know if your board is emailed on something that relates to its public jurisdiction, that a single person will be tasked with responding, whether it's a staff person, if you have a staff person, or the chairman only, and that you do not need to worry about looking responsive. And so in towns that have like that joint email address, they'll have a bounce back message that says, your message has been forwarded to the town administrator, planner, or whatever it might be, who will provide a response. Please feel free to contact them directly at this line. So that the board doesn't ever believe that they're not getting a response, and then the town administrator writes back to the board and says, I responded by an email dated this day, with the following. So that's not any open meeting law, anything. It completely avoids a violation, and the board members are confident that a response is being given, because responsiveness is, the issue there. Yes, sir?
Yes, and on that point, you mentioned if they respond, it could be a violation or something. I'm pretty computer illiterate, but, I get emails that say, no reply. In other words, you can't respond, you can't click reply, it doesn't go anywhere. I'm not sure how one does that, but would that be of use to something that's?
Yeah, I don't know, that's an email address, that's a no reply email address, so that's a different thing, and I don't know how to do that either, yeah.
Okay.
Just sending the email to your board members is the violation, if it's, I feel, I think, I believe, I wish, I hate, that's ridiculous, let's deal with that immediately. Just sending it is the violation. No one has to reply to create another violation. It's a violation just to send it, okay? The difference is if someone else emails a full board, it's not their feelings, ideas, beliefs, and concerns, not the board members' feelings, ideas, beliefs, and concerns, it's the individual who did the email. So responding to all with your, I feel, I think, I this, I that, that's creating the violation. Just receiving the email from the outside person doesn't create a violation. So if we just use Robin and the Board of Selectmen as an example, if Robin does an analysis of something and sends it to the board as a whole, the board can read, each member can read it, they can have their own opinions, etc. What they can't do is write back and say, fantastic idea, Robin, you've done a wonderful job with this. This captures exactly how I feel about this issue. Because that is now shared with a quorum of members. I think, I believe. They could have written back directly to Robin and said the same thing, not a violation. Okay? It's the reply to all that's dangerous, so just don't use it. All right? Yes?
So, if the town administrator gets a response from an individual selectman.
Yep.
What's the best practice so the things aren't happening in silos, so can they be scanned and put into the packet that's prepared that we get electronically, just so we have the information?
I know, it's
Do you know what I'm
frustrating.
saying?
Yeah, not exactly. The town administrator can give a report each week about things that are important. So if you're working on something, that can come in. But if she were to share a feeling, idea, belief, and concern from one person with a quorum, now essentially that would allow us to just kind of get around the open meeting law. Because the individual couldn't share it, but she could. So it would just like skirt the requirements of the open meeting law. And there's a few cases where that was actually the plan, that made sense so that everyone would be on the inside. They'd all know. And the court said, no way, cannot do it. You can't use an outside person to try and, not to try, but to avoid the requirements of the open meeting law. The best way to kind of set your mind up, I every single year I go to one town and do this same training, or training like this for them, and 2 water commissioners sit in the front row. And they're both architects. And they just are furious with me the whole time. And they say, there is no way I would ever go to a meeting in my professional world completely uninformed, and I won't do it now. And I say, well, I give the line about, I didn't write the law, and you should talk to your state senator and representative first. But I try to explain that that's true. It's true. None of us in our private lives would function like that, because we try to have the most information to make the best decisions. You have to kind of switch the way you're thinking about preparations, because under the open meeting law, the law contemplates that the decision making, the information sharing is going to happen at the table. That's the hard part. And so because of that, it's like when you start thinking about it more like that, you start realizing, oh, okay, well, individually we can get whatever information we need, but the place where we're going to share that is going to be at the table. That's why you can share your outside person's analysis, but not each other's. Okay? And I think it's frustrating, but when you try to think of it from the point of view what the law is trying to accomplish, and I'll give you another example. It is anticipated that in the future, it's going to be acceptable to email amongst members if you do it in a public forum. So if you do it on like a Google Doc, right? So anybody who wants to has access to the Google Doc and could go and look at it. Now that's not allowed. But the idea is, of course, if you have a record and you can just read it, why isn't that as good as me coming to the meeting, right? And now when we allow the meetings to be broadcast, we allow people to participate from home, what's the downside of having 5 selectmen or 5, Board of Water Commissioners or 5 assessors be able to just email about stuff as long as everyone else can read it in real time? So I think that's where the law will go, but it's just not there yet. It took a long time for email to show up, let alone, to social media, which I think is next. Okay? All right. Also, you want to assume, as we talked about, that the email is a public record if you're sending emails. And finally, that it could be forwarded to places where you don't want it to be. And I know a person who wrote an email to another board member. That other board member sent it to a totally different person. The totally different person sent it to a few other people. And someone who was on kind of a different side than these 2 first people sent it to a 3rd member of that board. And when they did that, it's a violation of the open meeting law. Not by the individual who sent it, but by the board. So you don't have control of an email after it leaves your hands. We all teach our children about social media and the risks. Like once it's out there, you can never get it back. But it actually is very true about email as well. You just have no idea. Okay? Don't ask for express opinions, ideas, feelings, or belief or impressions in an email to your other members. Anytime you start to say, because, I think, I feel, I wish, I believe, that's right, I agree, just take it back. Okay? So if you're a board member, one thing you could do is to do what the AG says, which is try not to use email for board business. Use it for scheduling, use it for the receipt of information, but don't use it to conduct business. Okay. It's annoying. I know. All right, so social media, also subject to the open meeting law. This poses new and more frustrating kinds of risks, especially in small towns. We find we're all in the same friend group. We share share messages that may or may not relate to our public business. It's risky, okay? If you are on Facebook and you have board members in your friend group and you call them out, the AG is going to say that's a violation of the open meeting law. So you cannot direct your comments about affordable housing to the other members of your affordable housing board, okay? This is obviously a real thing, which is why I'm saying it. You know they're going to be interested in it, but you can't call them out. So you can't say Lauren Goldberg is with blah, blah, blah in those. When you can't ask a question. Don't you think other members of the select board, ? You can't have them in there directly. If you see other members of your board have already commented on something and your comment would make it a quorum, what should you do? Don't comment. Now, I always have a First Amendment person in the audience who says, it's my First Amendment right to speak and I'm going to do it. And I get that. It is a First Amendment right, but it also creates a very significant risk for your board and the work that you do. Especially if it's something that's pending, especially if it's an adjudicatory or quasi-adjudicatory matter. If it's a land use matter, if it's a license matter, if it's a permitting matter, and you weigh in 3 of 5 members of a board, don't you think that predetermination and bias is going to be in the complaint that's filed in court when you reach a decision that this person doesn't like? Okay? And again, just like in the email context, you don't know who can see this stuff. So be careful about it. A lot of people have started having, Facebook pages for their campaigns if they're elected. When you're elected, you had your Facebook campaign page where you had all sorts of stuff that you took positions on and had opinions about and were really active and loud, and that's what people are looking for. When you become elected, you need to think, or appointed, let's say it's an affordable housing thing, because it's a really good example. People are really enthusiastic about affordable housing. If you continue to preach about the fantastic nature of something that you're then making decisions about over here, you can see that people may use that against your official action. So just be clear. This is my campaign page. This is my personal page. Okay? Sometimes what people will do after they're elected, and I'm back to my affordable housing person, this woman, huge affordable housing supporter, and she ran to develop affordable housing, to have people, you know, kind of change their mind about affordable housing in her town. And when she was elected, she got really worried that any decision that she made was going to be challenged as though she would approve any affordable housing, regardless of whether the facts and the evidence suggested that were presented in the law that that was a good decision for the town. So what she did is she decided to use her affordable housing page that she had campaigned on just as a clearinghouse for information. So she just posted other people's stuff on that page. And she used her own page, her personal page, for information purposes. So things like, you know, so the board will be hearing an application from so-and-so, 3 o'clock at the whatever, you know, town hall. Please join us, and, you know, we're looking for public input. So she made announcements, essentially. She used it for public safety purposes. So during storms, she would retweet or whatever the information posted by the DPW and by the National Weather Service. And so she kind of changed the way she used her social media when she was acting in a quasi-adjudicatory manner. If something's pending before your board, do not comment about it on social media, okay? It is a problem if something's pending, because that is going to look like you made a predetermination. One of the counselors, and I think it is Fitchburg, she does not post anything about her feelings about something while it's pending, but then afterwards she goes online immediately after the decision is made and gives her entire reasoning. And so then if people don't like the decision she made and they think her reasoning is faulty, they can talk to her about that. But she waits till after so it doesn't look like she prejudged. Okay? All right, yes.
The director sends us information ahead of time, it sounds like that's fine. But prior to a meeting, she asked us to think about,
Hypothetically, you mean?
yeah, think about, like an action statement kind
Yeah.
of thing. So, like compose something.
Mm-hmm.
So if we, each one wrote something down and said, would you just like read this before you come to the meeting, is that legitimate?
You shouldn't share beforehand.
Should not.
Right. You could share it with the director,
Yeah,
but not with each other.
okay.
Okay? Applicants have due process rights. They have the right to have their particular matter heard, and the evidence that's gonna be used, introduced at a public hearing, people providing testimony, and then a decision made after all that evidence is submitted. So if you are on social media about something that's pending before your board, they may have a due process claim. All right, so that's something else to be really careful about. Personal use, if that's the official and private, your personal capacity. Also, something important to think about is if there's something big going on. So let's say a construction project or, you know, a big override or something like that. Think about whether you should be doing that on your personal page. If people are asking you question after question after question after question, maybe instead the municipality should have a page. You know, these are the questions we're being asked. How much, you know, levy capacity, how much this, how much that. Rather than you answering it as kind of a pass-through, okay? Do not debate or discuss with members of the public. Oh, this is something else that I think is really difficult with social media and something to really be aware of. Sometimes the public wants to kind of get you to take a position on something, and so they will keep coming and coming and coming. You say something, they ask another question. You say something, they ask another question. That can get difficult, and especially if you don't want to get boxed in. It's fine for you to say, I'm going to wait to address these issues after, you know, at the public meeting or whatever, at the board's meeting on Tuesday. Thank you for raising these important questions. We'll deal with these on Tuesday. Something like that, so you don't get pushed into a particular space. The other thing is, we were talking about responding being important, and sometimes on social media, if there's something big that's going on, you feel like if you don't say something, you look like you don't care, and that's going to be a problem for people. So one of the things that I suggest saying is, obviously, all the members of the board, if you're the third person out of 5, all the members of the board have feelings about this. In order to avoid any potential violation of the open meeting law, I'll share mine on Wednesday at the board's meeting at 6 o'clock. So it's clear, you're invested, you're reading, but you're not gonna get into a debate, and it's fine to say, because I don't wanna violate the open meeting law. Which you would if you got into the substance, so, put it right out there for people. As an elected official or as an appointed official, I'm subject to the open meeting law, and therefore I can't weigh in where two other board members have, but come on Wednesday and I'm happy to share my opinions. Something like that. Okay, subcommittees, I think I mentioned this. They looked at 3 factors. If the group constitutes a subcommittee, is it within government? Are they empowered to act collectively? And are they serving a public purpose? Any board or committee that's subject to the open meeting law that appoints a subcommittee, that subcommittee is going to be subject to the open meeting law. How do you know if you're appointing a subcommittee? If 2 or more people are authorized to act collectively, it's a subcommittee. So Finance Committee is the best example of this. Finance Committee has liaisons to different departments. If Lauren and Robin are designated as board members to be as Finance Committee members to be the liaison to the Board of Selectmen, together, we are a subcommittee and we need to post. In contrast, if Lauren is tasked with being the liaison to the Board of Selectmen, there is no subcommittee. I'm not being tasked to operate with anyone else. There's no acting collectively. It is safest and easiest to designate one person to do something. Now, let's say I am tasked with doing the minutes and I have a question. And I say to person, X, do you think that's what happened? You're on my board. Am I violating the open meeting law? No. Because we were not tasked to do that collectively. I was tasked with writing the minutes, not the 2 of us together. The risk becomes if you then say to a third person, Lauren was telling me she was doing the minutes and she asked me blah, 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 what do you think? Now that's 3, that's a violation of the open meeting law. Okay? I will say that Betsy Lane, who is one of the founding members of our firm, and I tell this story every time because I love it. I went to training with her in the year 2000, so I could see how she did it. Now, I've been doing public records trainings, but she thought it would be good for me to go with her. And we start talking about the open meeting law, and she says it's absolutely a violation of the open meeting law for board members to talk to each other outside of a meeting. And I'm thinking, that's not what the law says. You guys saw the definition, right? It's a quorum of members deliberating about something that's within their jurisdiction. And she's like, oh no, you can't tell them it's okay because then they'll do it and it's a violation of the law when it gets to a quorum. Which is funny, but it's also true. I mean, we feel inclined to talk to our board members, our fellow board members. So if you are tasked to do something on your own, it's not inherently a violation as long as you have a 5-member board or bigger to talk to another person to get their feedback or their input. But it is a subcommittee subject to the open meeting law if they're tasked to do it together. Yes?
If 2 members of a 5-member board don't form a subcommittee but are appointed to go to a meeting for informational purposes to bring information back, is that considered a subcommittee, or is that just, they don't have formal representation, or?
If they're not authorized to act collectively, that's the question. Are they being asked to act collectively? If they're going to do it independently, fine. But there is a slippery slope there. Because if the 2 of them talk and then give a report, now they've acted collectively. See the difference?
Even though they don't make a decision on behalf of the board, just the fact
That's
that
right.
they discuss what took place.
Yes,
Forms a subcommittee.
that's right. They're acting collectively. That's the
Right.
question. So, 5-member zoning board of appeals, someone needs to write the decision. I'm tasked with writing the decision. I can write the decision all by myself, no problem. I could ask another member a question. Oh, do you remember what they said when blah, blah, blah? And let's just say that other member doesn't talk to anyone else. There's no subcommittee. There's no violation of the open meeting law. If, however, the 2 of us are tasked with writing that decision, now it is a subcommittee. It's not.
More specific, I guess, then, a meeting with the DEP to talk about something that's going on with the board, 2 members go
I would.
to avoid the need to post, no,
Probably not. Hypothetically,
hypothetically.
as I shake my head vehemently from side to side. Especially if it's on like official business, you have to imagine that they're going together. Like they're being asked to go together. If it's a together thing, they're subject to the open meeting law. Okay? All right. one person doesn't constitute a subcommittee ever. So one person is never a subcommittee. One person is never subject to the open meeting law. Conservative approach, oh, see, I wrote it down. When two or more people are tasked to accomplish something together, post the meetings and comply with the open meeting law. Committees created by a sole officer who has statutory authority to do something on their own, or other legal authority to do something on their own, do not create subcommittees when they, subject to the open meeting law, when they appoint a committee. So the superintendent has authority to appoint principals. Superintendent can appoint a committee as a search committee for the superintendent, and it is not subject to the open meeting law, because it's a committee of one person. Make sense? Rather than a committee of a committee, or a committee of the town, it's not, it's a committee of one person. But they have to have the sole authority to act. So let's just take the Conservation Commission. If the Conservation Commission, the conservation agent can do X, Y, or Z things, but the Conservation Committee says, Conservation Agent, appoint a committee to do X, Y, or Z. That doesn't work, because that's essentially the Conservation Committee making the appointments, okay? If a person has independent authority, they can do that. Also, I'll give you an example of what's a subcommittee and what's not, because this is useful. In one town, the Board of Selectmen appointed a bylaw review committee, town administrator, DPW director, town clerk, town moderator, and a few other people, appointed them as a committee. Guess what they were subject to? The open meeting law. Next town over, that they were modeling themselves after, the town administrator said, hey, at our department head meeting every week, let's take on the task of looking at these bylaws. Were they subject to the open meeting law? No. Okay? All right. Notice and agenda. At least 48 hours, as we said, date, time, place, a listing of topics, and I told you the topic is considered to be an item. The public needs to know what's going to actually be discussed. The sufficiency of the meeting notice is judged on its face and in the context of what was actually discussed. So you could get in trouble for posting an inadequate meeting notice just based on what the meeting notice looked like, or based on what you actually talked about and then comparing it to the meeting notice. Coming and going. All right, so these are just some practical things to think about. For a Monday meeting, the notice has to be posted Thursday. If Monday's a holiday, it still has to be posted on Thursday. Okay, because Monday won't count as part of the 48 weekday hours. The clerk should timestamp the notice to ensure that an accurate record exists of the filing. A meeting may not be continued from one night to the next unless the meeting is separately posted. So if I think that it's going to take us 3 nights of public hearings to get done with something, and I'm the chair or the board's clerk, I post for 3 nights, same agenda. If we wind up not using that 3rd night, that's fine. But if we need it, we have it. If it's not posted, we cannot have it on the 3rd. Okay, we couldn't have it on the 2nd. You can't post Monday, Tuesday, Wednesday, Thursday, Friday unless you actually, unless you actually think you're going to meet Monday, Tuesday, Wednesday, Thursday, Friday. So you have to have a reasonable belief you're actually going to do it. If you make a posting in an alternate location, you want to make sure that it's timely posted in both places. So if the requirement is that it be timely posted, that your posting location is the internet, it needs to be timely posted on the internet as well as in the clerk's office. And then the notice under the open meeting law doesn't substitute for any other notice. Zoning, conservation, planning, there's other notices that need to be sent, liquor licensing, those still need to be sent. They have nothing to do with the open meeting law. One does not substitute for the other. Location with the clerk, and then we already talked about that. Write out the terms. Don't use an acronym. I can't even remember. I can't speak anymore. Which you might be happy about. I don't know. Don't use those things. You want to write it out. So if it's the home program, you write out what the home program is. The meeting notice has to indicate the time and date of the posting. Okay? And if revised, so if something comes up within the 48 hours after it's been posted that was not reasonably anticipated by the chair, but the chair and the let's just say the staff person know that is going to need to be discussed, then you update the meeting notice. And when you update the meeting notice, you need to show the new time and date that it was updated. And you need to differentiate between what was old and what was new. So maybe you put everything that's new in bold and say a little star and say everything in bold was added on whatever the date was. Okay. What?
Does the revision have to comply with the 48 hours?
Not if it wasn't reasonably anticipated. So if something comes up, okay, the example I give for this is, it's the infamous bike committee story. There was a federal bike grant for bikeways, and in order to be eligible for the grant, you had to have a bike committee. And it was thought that the bike committee deadline for appointment was the end of November. But the federal government did something funky, and all of a sudden, the deadline for the appointment moved back to that day, whatever that day was. The town administrator tried to reach the chair of the board of selectmen, who was on a flight, couldn't be reached. She didn't feel like she had the authority to update the meeting notice without the chair telling her, so she didn't update it. That was that morning. He gets off the plane, she tells him, he says, fine, throw it on there. She throws it on there, they get to the meeting. People are up in arms. We didn't know about the bike committee, it wasn't on the meeting agenda, why are you doing this? And they explained because the deadline changed, it wasn't something we could have reasonably anticipated, it has to happen, that's why it's on there, that's why we're doing it, and the AG said that's fine. Contrast that to them finding out a week earlier. They found out a week earlier that that's what the deadline was, and they didn't have it on the meeting notice, the chair could have reasonably anticipated it and didn't put it on, and that's not okay. Yes, ma'am?
So if a board had a posting for tomorrow night, it had an executive session but had no information on what that executive session was going to be about, but they knew what they wanted to talk about, what should they do to fix that?
Update the meeting notice, but
Can they update it between now and tomorrow to?
hypothetically.
Hypothetically.
It depends what the chair could reasonably have known. If the chair could reasonably have known, but the meeting notice just didn't list it, then really what should happen is you should put off the executive session to a time when it can be properly posted. If you can't wait because of something, or, you know, there's I don't know, some repercussion that's significant, and it feels like that it's worth the risk, then you would go ahead and update and try to explain it if you were challenged. And this is kind of the difference between the best practices versus defensive action. There's times when we have to be more flexible than the open meeting law allows, and so then you try to do it in the closest way to okay as possible. The AG says if something's not on the agenda, the best practice is to put it off to a meeting where it can be properly posted. And that would include something that someone else raises at a meeting for the first time, or something that comes to the board's attention after the meeting notice is posted.
So the old way, people were afraid or resistant to actually put what on for executive sessions, what they were going to be talking about.
Yes.
So can you just say a little bit about
Yes.
what do they
Absolutely.
put on executive sessions?
Yes, that's a good question. So the open meeting law notice for executive session should, if it's anticipated that there will be an executive session, then executive session goes on to the meeting notice, and you can actually cite to the section that you intend to go into executive session for. So let's just say it's to consider the value of real property. So it'd be executive session in accordance with chapter 38, section 20A6 to consider the value of real property. I would just copy it right out of the statute. Now, because discussion of it in open session would be detrimental to the public's position, I wouldn't put the street address of that property in there. Unless everybody already knows, but that's what we're gonna be talking about, then you might put it in there. So under exemption 1 to the open meeting law, which is to deal with discipline or dismissal of an employee or complaints against an employee, typically we would not put the name of the employee in there, although we would still list exception A and all the reasons why. All the text from that. For collective bargaining, if you're going into executive session to do collective bargaining with a union, that union knows they're gonna be in executive session with you, you put that union's name on the agenda. On the other hand, if you're considering strategy with respect to collective bargaining, you may not wanna tip off any of the unions about which one you're going to be talking about strategy for. So in each case, you would include on the agenda the amount of information you can without destroying the reason that you need to be in executive session. And typically it's personal privacy, government on the same playing field as a person in the market, to protect the town's position in litigation, and there's security, the town acting as an employer, but typically is to put the town on equal footing as those in the private sector. Allow it to have a discussion in private. Yes?
I've seen on some meeting agendas where it says items not anticipated as an item.
Yeah.
And those have to be really good reason, otherwise you ought to postpone in discussing anything else you wanna bring up at that
Well-
meeting until you maybe can post another meeting a few days later.
There's a difference between what the law requires and what the law permits. So anything that's not reasonably anticipated can be discussed at a meeting. It's in a later slide. It's not prohibited. The law specifically allows for that. And a lot of towns used to have old business and new business on there and feel uncomfortable at taking those old business and new business items off. And so they'll put a star that says, to address, the public should be aware that matters not reasonably anticipated by the chair may be raised and discussed and even voted at this meeting, so that the public is aware. The AG encourages you to put it off if it doesn't require immediate action, but that doesn't mean it has to be. Okay? Whether it's a good idea or not depends on what it is. In my bike committee example, if they hadn't voted that night, then they wouldn't have gotten their grant. So yeah, there's a really good reason to vote that night. If it was gonna be 3 weeks later, they would have had to decide, is this something that we feel like we wanna deal with today? Or maybe the only thing they would have said is, hey, even though this wasn't on my, list of things I was gonna report on, I got contacted by the federal government and they've changed the bike committee appointment deadline, and it's 3 weeks from now, so you'll see it on your agenda next week.
But even if it doesn't require a vote or anything, it's just kind of information to the group,
Yeah,
that's okay?
I don't know what you mean by that's okay. If it's
You don't have to make it.
reasonably anticipated by the chair, it should be on the agenda.
Okay, but then if you add something that you didn't anticipate, but it's just a matter of informing you that requires no vote or no action by the board,
The
just information.
The AG will say if it came to you after the 48 hours and you have time to update the agenda, you should update it. Correspondence received, 3 letters, and then you get a 4th one, they would say update it. I didn't make these rules though. Okay, what can we talk about? Oh, this is that. I don't know, this is off a little bit. Matters not reasonably anticipated, the chair must be added to the agenda after the posting deadline to the extent possible. So if you plan to talk about something that wasn't reasonably anticipated, you have to update the agenda if you are able. Okay? Matters not reasonably anticipated by the chair may be discussed and acted upon. The AG recommends that matters that require immediate action be put off, that unless a matter requires immediate action, it be put off till a later meeting. That is not what the law says. All right, placeholders, now a no-go. That's what we were just kind of talking about. Regularly occurring items need more detail, so unless they are included to notify the public that unanticipated issues may be discussed, no new business, old business, and even the town administrator report has to be like, town administrator report, 3 items, whatever you anticipate you're gonna say. There may be, especially for a town administrator, or, a director of DPW or whatever it might be, there may be lots of things that happen within the 2 days that aren't so significant that they're gonna get updated on the agenda, because that would be silly. But if it was a significant thing, you would try to update the agenda. Emergencies, this is what I was saying, if there's an emergency, and most of you guys, I hope, are not having to make decisions about whether to hold emergency meetings. The example I like to give is on April 1st, for like the past 8 years or something, there's been a snowstorm. There's a lot of elections scheduled on April 1st, so boards of selectmen need to decide, do they want to cancel an election? So do they have to leave their homes in the middle of a snowstorm where no one can get out to go to town hall to have a meeting, or do they have to wait and post 48 hours in advance? No, they don't. That would be stupid. We can say that word here. And so they don't have to do that. They can have an emergency meeting if need be. You need to comply with the law to the extent you can. So I'll give you my famous example. A house in town is falling down. The building inspector's been watching the house falling down for a year. And the building inspector says to the chair, the Board of Health or something, hey, we got a problem with this house. It's falling down. And the Board of Health chair said, let's have a meeting right now. We're going to condemn the house. But it's been falling down for a year. So the emergency is non-existent. It's not an emergency. You can't hold an emergency meeting. As compared to, there is a fire, and the building inspector goes out and says, holy cow, that house is about to fall down. call the board of health chair, we need to condemn the house, okay, let's get a meeting together right away. Because one is a pressing immediate emergency and the other is not. Man-made emergencies are not emergencies, so for example, a filing deadline, a constructive appeal. Whether to hold a meeting in those circumstances and ratify, validate, and confirm later is a different thing. Sometimes there's reasons why we do things that may not look immediately compliant with law, but as a general rule, just realizing that your clock is gonna run out is not enough to hold an emergency meeting. It has to be something that's actually an emergency. When you have an emergency meeting, post another meeting immediately after that, like in compliance with the law. So you have your emergency meeting, that afternoon, but you post for 48 weekday hours after. And then at that meeting, you ratify, validate, and confirm what you did at the first meeting. It's not just saying ratify, validate, and confirm. You actually have a brief discussion, rehash what you discussed, take a confirmatory vote, and then attach the minutes of the first meeting to the minutes of the second. Okay? Recording, wiretap law, under the new version of the open meeting law, any person still has a right to record, but they have to tell the chair, and the chair has to announce that it's being recorded. So even at a meeting where your public access broadcast people are present, you should announce it. They have to inform the chair. The chair still has the right to say, you cannot shove that microphone in my board members' faces. You can put your microphone down on the table, or you can set your video camera up in the back of the room. This is the executive session, Robin. First, you convene an open session. You state the purpose, stating all subjects that may be revealed without compromising the purpose for which the executive session is called. You take and record a roll call vote to go into executive session. You announce if you're going to have the open session and reconvene after. Why?
So people know.
So people know if they can go home or not. If you're going to come back, then they might want to stay. You maintain the exhibits and documents and list used at the meeting in reasonable proximity to the minutes. Now, what does that mean? You don't have to keep, especially in zoning and planning boards, or conservation, I'm gonna have to keep this giant plan, we use this giant plan, I have to keep that with the minutes? No, but you have to keep it in the office. So if normally you would put that back into storage or whatever, you'd keep it around for 6 months. You can only discuss the matter that is cited in the meeting notice and stated when you go into executive session, and you take all votes in executive session by roll call. Okay, that is a little panda holding a checklist. It's a panda with a checklist. Why do we go into executive session? To talk about reputation, character, physical condition, or mental health rather than professional competence of an individual, whether a town employee or not, or to discuss discipline or dismissal of or complaints or charges brought against a public officer, employee, staff member, or individual. In addition to the regular posting rules, you also have to give 48 weekday hour notice to the individual who's going to be discussed. To conduct strategy sessions in preparation for negotiations with non-union personnel, or to conduct collective bargaining sessions or contract negotiations with non-union personnel. If you're conducting a strategy session in preparation for negotiations with non-union personnel, you don't have to put the person's name in there, because then that would tip them off as to what was happening. On the other hand, if you're conducting a collective bargaining session or conducting contract negotiations with non-union personnel, they're actually going to be there. So they know, and it's their privacy that's being protected, so the name goes in. Strategy with respect to collective bargaining or litigation, if an open meeting may have a detrimental effect on the bargaining or litigating position of the public body and the chair so declares. So if you're going to be talking strategy, again, if it would tip them off to something, you don't put the name of the union in. If it wouldn't, then you can go ahead and put it in. If it's not going to affect the status of the litigation, you put the name of the case in the meeting notice. If it is going to affect, oh, this will tip them off that we're going to file an appeal or something, then you wouldn't. And the chair has to make a declaration that meeting in open session would be detrimental. Consider purchase, exchange, lease, or value of real property if the chair declares an open meeting would have a detrimental effect on the negotiating position of the public body. And you might say, well, if people already know the address, is it really detrimental to meet in open session? Yes, if we're going to go in and talk about an appraised value of a building or a piece of land, we don't have to disclose that appraisal publicly, even if everybody knows we want to buy 1 Main Street or whatever it is. Oh, I can't even read that. Executive session, practical issues. This is what we were talking about, Robin. If executive session is anticipated, it must be listed in appropriate detail on the meeting notice with such specificity as is possible without compromising the purposes of the session. So each case, it's a case-by-case basis you have to analyze. The related vote to enter executive session has to also include all of the information possible without compromising the purpose. And the declaration that's required has to be made. Content and meeting minutes, we talked about this a little bit. Date, time, place of meeting, and members present and absent. 10 years from now, no one's gonna remember who the fifth person on that board was. You gotta put their name in there. A detailed summary and discussion of each topic, allow a person that's not present to understand the substance of what occurred. Decisions made, actions taken, and votes recorded. No secret ballots in open session or in executive session. People have to just vote. And the list of documents and other exhibits used by the body. How do we know if something's used? The document's physically present, it's referred to, and the content of it is discussed by the members. So just because I say, I have read an important study and I have it right here, blah, 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 but no one says, oh, read to me from that study, because they're like, please, let's not read the study. That doesn't automatically become used at. On the other hand, if I hand out to every member a particular document, and I say, I want us to read this, then I want to talk about this line by line. Now it's a document used by the body, okay? So again, it's a little bit of you have to kind of analyze the way that it was used at the meeting. If it was just referred to, it's not present, and it's not used. If it's present and relied upon, then it's used. A lot of times this comes up with evaluations. If an individual has done an evaluation of another person, and they come in and they sit down and they say, let me read to you from my individual evaluation. I said blah, 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 and blah, 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 and blah, blah, blah. Well, that might make it a public record, as compared to just saying, I've done your evaluation, and in my opinion, you did a good job. Or in my opinion, you had a problem with X. I didn't then make that actual written evaluation public, because I didn't talk about it. I didn't read from it. Okay?
On your voting.
Yep.
If you have everybody voting for, you can just say you voted unanimously. If you had somebody.
Not in executive session.
No, but this is.
In open session,
in
yes.
Open session.
As long as you have the people absent as well, so it's clear.
Okay, so if you have the, who's in attendance
Yep.
at the very top, and if there's a no vote, you have to identify the person who voted no?
No.
Okay. Cause then it's still anonymous as who voted no versus yes.
Yeah, in executive session, it has to be a roll call vote. It's not required to be a roll call vote in open session.
Back to the minutes.
Sorry?
Back to the minutes. We post more often than not, just to be safe than sorry, if we have a quorum show up to an informational meeting. If we don't have a quorum show up, what do we have to do for minutes? Do we have to do minutes to show that no meeting was had?
No.
Or no quorum was present?
No.
Okay.
The meeting didn't take
If we
place.
have an agenda and only 2 people show up, what we found that we're doing for best practices is we're stating what happened so that there is a record for people
I
who are
see.
still looking for those minutes.
They're looking for the minutes, so that's a way to kind of, it's an administrative thing. It's not really minutes, it's more of an administrative note. I will say, just on the issue of people not showing up, be careful about being at meetings where people don't show up, okay? If you go to a meeting, you have a 5-member board, and you don't get a quorum, don't stay and chat about the matters that were before the board. Because there's a due process issue with that. There's also the problem of you going back and then saying to the persons who were absent, or one person saying, oh, well, blah, 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 this is what happened. What immediately happens is a violation of the open meeting law, okay? If the board doesn't show up, if there's not a quorum, thank you, apologize, meeting canceled, and maybe you continue the meeting if it's a public hearing to a different time, date, and place, more than 48 hours out, but you do not discuss with the public who has shown up what the issues are. Okay. The new regulations provide that the approval of minutes must occur generally within the next 3 meetings or within 30 days, whichever is later. Okay. Minutes of an open meeting are public records as the moment of their creation, and upon request, minutes have to be made available within 10 days, like anything else. But this law didn't get updated, so this still says 10 days, even though the public records law says 10 business days. I don't know what the right answer is, other than to say if you have them posted, you don't have to worry about it. There's also a new way to approve the minutes, and that is that you can designate a single person to approve the minutes on your board. You can designate a person, I mean, you can have them on the bottom of the agenda in the consent calendar, and unless someone objects, then they're all deemed to be approved at the end of the meeting. Or you can do it in the way that you probably have been, which is everybody weighs in. Executive session minutes also have to be approved in the same way. 3 meetings or 30 days, whichever is later. They're also supposed to be just as detailed. They can be withheld until the purpose of the exemption has been met unless they're otherwise protected under the public records law, in which case, even though the AG says the purpose has been met and they would otherwise have to be disclosed, you can assert an exemption under the public records law. We have still taken the position, for example, that if you're in executive session for privacy reasons, even if a decision is made, the individual still has a level of privacy, and so we would say the exemption under the open meeting law still applies. So we assert both the exemption under the open meeting law, which operates through exemption A of the public records law, and the privacy exemption under the public records law in that example. The chair of that public body is directed to review executive session minutes periodically. So if you have a backlog of executive session minutes, start taking a look at them. They can be approved in executive session either under exemption 7 and listing the date and the purpose that you were in the first place, or you could do it under the original exemption and you'd say to approve minutes of the whatever meeting. Okay? So if you're going in for more than one set of minutes, you're likely to use exemption 7.
If we go into executive session for item 6 and we're also going to approve minutes, do we have to identify those minutes
Yes,
in the posting,
yes,
in the open meeting posting?
yes. So if you're going in to approve executive session minutes,
Yeah, well, we're going in, say, for item 6,
yep,
but we're also going to approve executive session minutes from our last meeting, executive session.
Yes.
minutes.
Then
Those
you-
have to be spelled out.
yes.
And the reason we went into executive session for those?
You
minutes?
just repeat it. Just take it right off the old agenda and put it on the new one. So it would say, approve executive session minutes from whatever date, and then you have the reason that you went. Complaints. Complaints can be filed within 30 days of the alleged violation. They're filed with the public body. They have to be forwarded to the AG within 14 business days of receipt, within essentially a resolution. What did the body do with that complaint? Any remedial action taken? And then the complainant can file a complaint with the AG after 30 days from the date the complaint was filed with the public body. They have to use the form that the AG has issued to make a complaint. If they don't use the form, it's not a real open meeting law complaint. The public body, even though a court has said that the public body doesn't actually have to hold a meeting to deal with the complaint, the Attorney General says you do, so you do. So essentially, you put on the agenda, open meeting law complaint, the person's name and the date and whatever basically they're alleging, alleged violation, acknowledge receipt of complaint, discuss resolution and vote, something like that. Yeah, this is, so the matter must appear in the notice, it must acknowledge receipt, deliberate concerning allegations. A lot of times it's very tempting to just say, we'll let counsel handle that. You really have to at least say, this is what they allege, we don't think we did that thing, therefore we're directing counsel to write something. Vote to resolve the complaint, whatever it's gonna be, and if appropriate, authorize a response to be prepared to be sent to the Attorney General and the complainant, and that's by the 14 business days, okay? Cure is a real thing, it is still available under the new open meeting law, and that is public deliberation at a properly posted open meeting effectively cures a private deliberation, a violation of the open meeting law. So here it was one that occurred over email because it enabled the public to see the discussion that went into the creation of the policy. To cure a violation, the public body must make an independent deliberative action and not merely a ceremony acceptance or perfunctory ratification of a secret decision. So if there was an email exchange, you put on the agenda, discuss email exchange, Ray, whatever. You have a discussion about it. Then I said this, and you said that, and you said this. It's not, the chair can do the summary. Basically, it seemed like we were all in agreement about policy X. Can we talk about that for a little bit? And then the chair facilitates by saying, do you have something to offer? Do you have something to offer? Do you have something to offer? Then once everyone said something, say, okay, I think we're ready for a vote now. Let's ratify, validate, and confirm the decision that we made via email, and that is to blah, blah, blah. And you take the vote, and you attach those emails to the minutes of the current meeting, and now you've cured the violation. Now, the reason I'm telling you about cure is because you don't have to wait till you get a formal complaint filed. You can cure a violation on your own before the complaint is filed. If you recognize that your board or committee has violated the open meeting law, just say to the chair, please put this on the agenda. Here's the agenda item, and then you'll have it. And then you'll do that before a complaint is filed. The Attorney General has broad and significant authority. The use of a hammer, okay, they have it. They can fine you $1,000 for every intentional violation, and they will do so. They also have the ability to undo action taken by the body. That is something that previously only a court could do. So let's say the board made a secret decision about a 40B, in private. They emailed and they decided X, Y, or Z. The board, and they decided to reject it. The AG could say, you can't have made that decision, you must revisit that. Or let's say a permit was granted on something. The AG could say, no, we're revoking that decision. You have to redo that. So that is a significant amount of authority. The AG can file in Superior Court to enforce, and 3 registered voters can bring an action in Superior Court as well.
So they could re-meet and come up with the same decision after deliberating on that?
They could. But still, it's, you make a decision, you think your decision is it, and someone appeals that either to court or to the AG and says, no, that decision was made in violation of the open meeting law. So it could be a big deal.
But then they can go back to a regular meeting to do the cure.
In theory. Yeah. In theory. Well, no, a cure wouldn't matter. If you're ordered to redo something, you're not curing it. You'd have to go through the whole process again. If it was testimony, deliberations, evidence submitted, you'd have to do it over. Not just a cure.
I'm just thinking of real simple
Simple things that are violations you could fix with cure. But if you're doing the same thing over and over, the AG is not going to look at it as an inadvertent violation. They're going to look at it as intentional. Well, I'm at the end. That's it. Yes?
Quick question, technology question. What's the validity of a person attending a meeting virtually?
So, remote participation or someone else wanting to call in who's not in the board?
Remote participation, someone who's on the board, maybe to
Yep.
complete a form or to.
Yep.
I can answer that.
Oh, great.
He just started, so he doesn't know about it. We do have a policy for remote participation. It's a board selecting policy. It follows the law exactly. And if you want that policy, you can get it from our office.
The short answer is it's up to the Board of Selectmen to decide whether it's allowed. And if it is allowed, it basically has to be for a reason that is listed in the statute, in the regulations, and it's that you're out of town, you're this, you're that. You have to tell the chair, then the chair has to provide for the participation remotely. You have to be able to hear and see. If it's done with a visual, then everybody has to be able to see each other. You have to take every vote by roll call. So, and you need an actual quorum present in the room for someone to be able to participate by remote.
So it
So
has to be.
a physical quorum present, and then someone can participate by remote. Yes?
So a quick question about documents discussed at an open meeting
Yes.
by a board.
Yes.
If they're discussing it, let's use a policy for example,
Mhm.
maybe they're discussing it, does the board have to make the policy or that document available so the people in attendance or the people watching actually know what you're discussing? Is that, I don't know.
That's a good question. There's nothing that says that you have to, if you're gonna be working on something, there's nothing that says everyone in the room has to have it. However, after the fact, if you've used a document at the meeting, then it becomes a document used at the meeting, it would get listed, and it would be, if it was an open meeting, it'd be subject to disclosure upon request. And a lot of times we actually do see this, and sometimes I think people misunderstand. It's like, just because you got a draft, especially, we're talking today about how you can't really go back and forth about drafts ahead of time. So you get a draft of something at a meeting, it could be the first time you've ever seen it, doesn't mean everyone else in the room gets to have it. Certainly there's nothing that prohibits making it available as well, but right now that's not part of the requirement under the open meeting.
But just regarding policy in general, I think best practice is to actually read through the policy and then, so everyone's on the same page when we're talking about policies, yes?
Yeah. I can't see any downside of that other than if it's really long. On the same, and at the same time, if you don't want to read it all, I think it's fine to make copies and have them available, but it's not required by the law. Okay. Yes, ma'am.
Okay, it said that you don't have to attach to the minutes something that's referenced in them, but you need to keep it. Does that mean, where does that get kept?
Right, so this is what I was saying about, let's just say we're talking about giant plans, you know, so you keep the giant plan in the office for at least 6 months. And then after that, it can go back to wherever it would normally be stored.
So, but if it's just a big document that you were looking through, can that just be stored in the office?
Absolutely.
Okay.
Yep, it just has to be accessible easily if someone comes in and wants to see it. Yes,
Someone makes a public records request, it's not answered. The person does nothing in reply, they don't file a complaint, they just forget about it. Is there statute of limitations? How, that they could come back later and say, hey, remember that thing I asked you about last year, you never gave to me?
that's a good question. Public records law. I can't think of a statute of limitations on a public records law violation, but, they have 90 days to, yeah, that's, if they do nothing and you do nothing, I don't know. If you do something, you write back to them and they have 90 days to appeal. So, you know what, I think it's 90 days from
When they
from
pick
the,
up again.
from a non-response.
Right.
Yeah.
And just one more question, let's say in a city council, you have a city council meeting, that's an open meeting, now you have a counselor. The counselor asks an administrative official at the meeting for information verbal.
Yeah.
They write it down into the minutes, they say, okay, we're gonna get you that information. Number one, is that a public records request? No.
I don't think so. I don't think so because they're making that request in their official capacity. They're not saying, I as an individual am looking for X, Y, or Z. They're saying, because I'm a counselor, I demand that this information be provided to me. That's different than a public records request, in my view. Hypothetically. Anybody else? Well, I must say, I'm very grateful to all of you for waiting and staying, and good questions, and, you know, there's a lot to take in. No one threw anything, so I guess that's a good outcome. So thank you very much for your time.
Yeah, they see you, they'll die, right?
Did you get to see the parade? Did you get to see the parade, Boston?
If you haven't signed the sign-in sheet, please, do so, we actually get credit for having people
Oh, yeah.
on our insurance.
Well, what if
I know.
she said they've got something we can use?